Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not for
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
We're getting commentary on the case. Dati mihi Anglican praise verbis Latinum.
Literally not true.
I didn't ask you to interrupt
Is that
me.
correct?
Oh, for Trump's sake.
Good morning. Oh, that's not right. Let's try this one. Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. There we go. Happy Friday. We made it to the weekend, and not a day too soon, if I say so myself. It was close. It was close there for a bit. But we are in fact, all the way to Friday. And if we're not, don't tell me otherwise, because I'm not working tomorrow. How's everybody doing? Good morning to you. Got some fun stuff on tap for you today, which we're excited to bring you. It's a long week, says Mindy. Guess who it's going to be a long day for? Not going to give any hints, but Winter Sky. You were first in chat today. That makes you the owner of the internet. Everything up here later worldwide is your responsibility. Congratulations. Good riddance. Is this your first win, Winter Sky? I know recently, I just checked the last few pages of the logbook. I hadn't seen an offense from you. So this might be a first offense. If it is, hopefully you learn your lesson. But good riddance. Good congratulations as well. Anyway, welcome. Mama of not. Mom, I was going to say Mama of 9. Mamau. I'm sorry. Mamau. Getting closer to being OG. 20 months. You are an OG. That is it. 20 months. OG. Mamau, congratulations. I almost called you a Mama of 9, which you might be, but I doubt. You might be. If correct me if I'm wrong, but Mama 09. There we go. I just added the F, the of. That little it changes everything, doesn't it? Surprise! You got 9. All right. Yes, I am. There you go. All right. Congratulations. That's wonderful. I come from a family of 10, so big families are a lot of fun. All right. Good morning. Hope y'all are doing just great. What is going on there? Let's go ahead and hit that button. That's Florida. A little Florida. All right. Good morning. I saw a few of you at the podcast. Thank you very much for being there. We had a lot of fun. If you missed it, do go back and watch it. It's well worth it. 0 dad jokes. 0. But there was some toilet humor. So it's a trade-off. So you get what you pay for. Vanishine, thank you very much. TGIF. Thanks for this huge super chat to kick things off this morning. That makes it all possible. Thank you very much. Good afternoon from Poland. Beginner Crafter. Welcome. I'm guessing you're not a beginner anymore. Is that how long can you claim the beginner crafter? Let me just do a little research. You joined when I joined in 2016. You can't be a beginner anymore. I'm sorry, you're going to have to change your name to expert. I'm just kidding. Beginner Crafter, welcome and hello to Poland. Putting puppy in the title made the button become like a paw. I have no idea what you're talking about, but it sounds fascinating, Red. The button became like a paw. Oh, there's so many new crafts to begin. You're right. You just might continue beginning other ones. All right. Like button. Oh, the like button. Nice. It actually, hang on. It did that? Hold, please. Now I want to look. I can't find it. It's not working for me. I'm glad you guys got the paw, but that's good. All right, let's do birthdays, can we? Before we get too far. We've got KO, Linda Lou, Megs, Dragon, and Elijah all celebrating today and tomorrow. So everyone, wherever you are, if it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. It's a paw after cookie. All right, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear KO, Linda Lou, Megs, Dragon, and Elijah. Happy birthday to you. KO, Linda Lou, Megs, Dragon, and Elijah. Happy birthday. Many wonderful days, but today is your special day. And I realize there are a million places you can be and a billion people you could have celebrated with, but you chose to be right here with us. The privilege, pleasure, the honor, the joy, that's ours. Hopefully you can turn that joy right back to you, though, and make it your day just a little more special. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlop's Hills, Andy's Grill, Bob Evans, and Cracker Barrel. First try. Nailed it. The whole thing. It's a paw after... I'm going to do it now. Let's do this together, shall we? Let's turn that off and then go here. Shrink that down and then go here. Make that big. And then I'm gonna like my own stream, which I must have forgotten to do. And it does become a paw. That is so cool. I'm gonna unlike. You can do it over and over. It becomes a paw right down here. Okay, that's really cool. And yes, YouTube did that and fixed that instead of, I don't know, fixing alerts and other things. But we won't get mad at them. It's adorable. We need to have puppy in the title from now on. What is the puppy dog verdict? Oh, you are in luck, or not, depending on the case. But you'll know in just a minute. You'll know in just a brief minute. Dancers, come on! This is what you practiced for. Get the let outs. It's inspirational. Air drum finish. If you slowed that down to like 3 frames a second, you would see I nailed every single beat properly. I am, in fact, a professional air drummer. No longer a beginner. Welcome, one and all. We have, not yet. Let's see. Yeah, it's actually too high. My son just came in to check to see if the counter was working yet. I have a whole drum kit. Red, I imagine you actually sit down at the actual drums and pick up the drumsticks and just play along. Rest your legs for today. Extra practice. Yes, everyone have a seat. Practice after the live stream. All right. Josh, that is that not the silver one, or is it a different Minecraft one? We're gonna start with what we got yesterday. Let me see if I can time this absolutely perfectly. So I have to have audio on. Ready? Have to get. It's a weird way to start the show, but here we go. Let's give it a play. There we go. All right. This view you're seeing is the courtroom, where we are following. Very rare for us to follow a divorce case that caught our attention mid-trial. We went back and watched a great deal of it, not all of it. We didn't need all the details. There's some things that I think should be private and not aired in court, and we skipped that part. Different one. Awesome, Josh. That's awesome.
We have a verdict. So I will bring the jury out in a minute. Ms. Yarber, is there anything we need to cover before I bring the jury out and receive the verdict? Mr. Polanco? Okay. Mr. Piner and Mr. Terry, I don't know if you ever had a jury trial before, but it is important that while the verdict is being published, the foreperson will actually read the verdict aloud, that you all remain stoic. It may not be what you wanted to hear, it may be exactly what you wanted to hear, but no outbursts, I can't believe that, anything like that. I don't say that because I expect anything like that from either of you. This is just a different situation. And so I provide that cautionary instruction. You'll have time of planning to talk with your lawyer about what does this mean, why do you think this happened, etc. Okay. Let's bring the jury in.
All right. Judge McBurney gives the order, remain stoic during the verdict. We have a verdict in this case. This is a divorce case. The verdict includes whether or not they can get divorced, what the grounds are, and more importantly, who gets the puppy dog. That's what we're here for. Everything else is sort of incidental to that, but the jury will come to a conclusion that they divide the assets here. They divide everything. The assets, the liabilities, and the ownership of the dog. So they're coming into the courtroom now. We're going to listen to the verdict, and then we'll get started with our other court watch for the day. Justice for Souza.
You got the out. I was going to say, we shouldn't have 14. You can take a seat, except for you, Mr. Lynn. Stay standing.
All right, we brought the
alternate. You did not participate in deliberations, correct? You were brought in after the verdict was reached.
Yes.
Okay. All right.
We got nothing out.
No, good. I know that's where you started. I just was surprised that there were 14 people, but as long as Deputy Gordon got you after the rest of the jury was done, that's not an issue. Mr. Lynn, you're the foreperson?
Yes, Your Honor.
All right, and the jury's reached a verdict?
Your Honor, we have.
Did you complete the verdict form?
We did.
Okay, if you give it to Deputy Gordon, take a quick look at it.
All right, the judge is going to review the paperwork, make sure everything's done correctly, and then the verdict will be read here in open court as everyone remains standing, and this is the view we get. It's sort of like the Headless Horseman view, but at least the audio's good.
All right. Gordon, I'm going to ask you, sir, to publish the verdict, which means starting not at the very top where it says Fulton County, but Section 1, divorce. If you'll just read in to the record what you and your colleagues decided.
Sure. So part 1 for divorce, both parties have petitioned for divorce. And we, the jury, find the divorce is based on the following ground, which is irretrievably broken. Determination of separate property.
You can't fix that.
We, the jury, find as follows. A little confusing for this partner. I think we made a mistake. This goes on.
I think we made a mistake.
Marital property for the two.
Okay, why don't you hand me the verdict again?
This is why I wrote it on the second page instead.
While we're watching the verdict as they sort out the differences, I think they got it. Watch the hands that are visible. Watch the hands, top of the screen.
So why don't you read it all on the record? I'll talk with the lawyers and we'll see how we handle that.
Okay.
It's not inconsistent, but you did put it in 2 places.
Got it.
You doubled up.
So we, the jury, find the following. Petitioner Piner's separate property is the Prius goes to Piner. Respondent Terry's separate property is Sozo, goes to Mr. Terry. Everything in storage is to be retrieved by the end of August in the year 2026. An equitable division of marital property. Petitioner Piner is awarded the Prius. Respondent Terry is awarded Sozo, the dog. Petitioner Piner shall assume and pay for all of his own debts. Respondent Terry shall assume and pay for all of his own debts as well. In the matter of alimony, we find Respondent Terry not entitled to alimony.
They said get a
There
job.
was one section about property in the storage facility. Did you indicate in your verdict form who it was who was supposed to collect that property and to whom it would belong? Or you said?
Yes. So, Your Honor, it belongs to Mr. Terry, and everything in the storage needs to be treated by the end of August 2026.
Okay, so it's Mr. Terry who needs to get that and get it out of there by the end of this month.
Correct.
Understood? Thank you. Deputy Gordon, if you would, and you signed and dated
And the
jury,
lights
the
clipping
verdict
like
form? All right, if you get that to Ms. Yarber, please.
So the gentleman at the top of the screen got the dog and no money, and he also got all his stuff in the storage unit. The guy at the bottom got the Prius and
Ms. Yarber, do you have any concerns about the form
debt.
of the verdict?
because it was all in his name.
Judge, one concern, I guess, under the alimony section, there are multiple no's that could be selected.
That's the way it's
It
supposed
is
to be.
inferred from the first one, when they asked if Respondent Terry is entitled to alimony, that the no would cover the rest of them.
In fact,
I
the
believe
instruction immediately following that is if you
Okay.
circle no on the first one, you're to skip
Skip
the
skip
remainder, which they did. If your answer is no, you are done.
Okay,
Sign and date the verdict. And they circled no. And then if you keep going, the next thing is the dated and signed verdict.
perfect.
Okay?
Thank you, Judge.
You're welcome. Mr. Polanco, any concerns about the form of the verdict?
No, but I'm just referring to what Mr. Foreperson, Mr. Lynn said, that something was mentioned twice. I didn't see it really listed twice,
Well,
but I don't know. if
they
I'm wrong.
put
Souza.
the Prius as both Mr. Piner's separate out-of-marital estate property, as well as something as a result of the equitable division of the marital estate, the Prius went to Mr. Piner. And then the same with Sozo. They put Sozo on the verdict form, that's separate property, not part of the estate, but also said it is part of the estate. Sozo is part of the estate, but it goes to Mr. Terry. Because the distributions are the same or the allocations are the same, I view this as a non-material defect. I don't think we need to send the jury back. If they had said, Mr. Piner gets Sozo, not part of the property, the marital estate, and then Mr. Terry gets Sozo, part of the marital, hey, wait a minute.
Yeah, it's
Sozo
not-
can go to one place.
The result is the same. It's not inconsistent, right?
I agree. With that explanation, you're accepting the form of the verdict.
Oh, no.
You're not
Other than-
accepting it?
No.
You're not accepting the form of it. So what is your legal objection?
No, I'm not objecting.
Oh, okay, good, okay. Excellent.
Listen to the question.
Anything else, Ms. Yarber, before I release the jury?
No, Judge.
Mr. Polanco?
No, sir.
All right, ladies and gentlemen, on behalf of Mr. Piner and his attorney, Mr. Terry and his attorney, I want to thank you for the 3 days that you've given us. I'm going to ask you to retire to the jury room. I'm going to be back there in just a minute to thank you a little more thoroughly, answer any questions you may have, and then you'll be on your way. But I hope you know that you brought closure to a situation that Mr. Piner and Mr. Terry weren't able to achieve without your involvement. It's like I told you Tuesday morning, you're here for an important purpose. And as you surveyed things, you may have thought, well, why couldn't this be sorted out? It wasn't. It wasn't sorted out, and we call upon the community to do it, and you've done that. And there's a punctuation mark at the end of this situation now. The case is closed. Mr. Piner's going to go his way. Mr. Terry's going to go his, and you've allowed that to happen. So thank you for your time. I'll see you in a second.
I'll run the jury.
The jury leaves now, having successfully ended this contractual situation, and split the property. But they did so pretty just like they cut the ties and just said it is how it is. Other than assigning the dog and the Prius, there wasn't much work for them to do. They did not award any alimony.
Ms. Yarber, anything else on behalf of Mr. Piner?
No, Judge.
Mr. Polanco, anything else on behalf of Mr. Terry?
No, Your Honor. Thank you.
I'll get the verdict filed, and we'll take it from there. If there was nothing else, then Mr. Piner, you and Ms. Yarber should go first. And when Deputy Gordon gives you, Mr. Terry, the green light, you and Mr. Polanco can go. And I wish you both the best going forward. I hope there are some positive memories from your time together. That chapter has closed. You should know, Mr. Terry, that whatever is still in place as conditions of bond, totally unchanged by these results. So if there are things you're supposed to not do because Judge Leffridge or another judge put it in that bond order, that's still the case. This dealt with your marital situation and the property that was connected with that. It doesn't have anything to do with the stalking case. You've still got a great lawyer plugged in with that. Keep him posted, follow his advice, but don't assume that anything's changed on that front because of this, okay? All right?
Sorry, just may I ask, so I was thinking this morning, logistically, can we get help from sheriff's office, or how do these things actually get executed?
It's a great question, and I'd ask you to talk with Ms. Yarber, not now because it's 5:30 and it's been a long week, but reach out to Ms. Yarber or Mr. Castellan. If you hit a dead end with them, I'm happy to get in the mix and say, come on, people. But we need to sort out how Mr. Terry gets Sozo and how Mr. Terry gets access to the storage unit. This verdict, those are the only two touch points. And so we can sort out if there's a third party where Sozo would be delivered to mutual friend X, not for safekeeping, but you are making this up. You drop him off at 10 and at 10:15, Mr. Terry shows up and he has Sozo. The lawyers need to sort that out so that Mr. Terry isn't inadvertently in your space. You can agree that this is the way we're going to do it, Mr. Piner, where actually Mr. Terry is briefly in your space, but you're not required to compromise that safe zone that's been created to achieve these two ends, which is get Mr. Terry into that storage unit, not at midnight on just one night, but accesses a lot of stuff he needs to get out of there.
His name's on it.
Yeah.
Pardon me?
His name is on it, but Your Honor, we will work it out among.
Good. The lawyers will work it out.
Make sure she has the keys.
Good.
And sign any
We can do it,
lock
Judge.
break thing.
Yeah.
We'll get it done.
Excellent.
Thank you, Judge.
You're welcome.
Thank you, Judge.
Scoot.
Get out. Scoot.
Thank you very much. Thank you.
You're welcome.
Shoot, wait.
Okay.
Listen.
All right, so you sit tight until Deputy Gordon gives you the green light. He just needs to make sure that Mr. Piner is on his way. Okay?
You got it. You got a really good judge.
You're a very good judge. You've been a great judge. All right. It's over. It's over. Literally. It's all the way over for them. So now we're going to go to Minecraft Court, where this is a silver issue. We talked about silver just a little bit this last week. So let's go there. And as usual, the court recorder is sleeping on her feet. This is her preferred position. I'm impressed. She sits a lot during the day, but this is how she rolls.
Seated. Cuts.
Thank you, Your Honor. We're here today in the state of Ohio versus Jason Shepard, case number 26CR000818. Defendant is present in open court today with his counsel, Nicole Novotny. Your Honor, we're here today for sentencing. The defendant was last before Your Honor on June 30th of 2026, where he pled guilty to count 1, grand theft, a felony of the 4th degree,
Grand
and
theft.
the lesser included offense of count 3, attempted tampering with evidence, a felony of the 4th degree. At that time, a pre-sentence report and victim impact statement were ordered. The state's understanding the pre-sentence report was completed and provided to the court, as well as documentation regarding the deductible was provided. All parties are prepared to go to sentencing at this time to the state's knowledge.
Josh, what are we counting? I want to to a mistake.
Yes, Your Honor.
Counter.
With regard to the instant matter that's in front of you, Your Honor, we'd like the court to consider community control for Mr. Shepard. After having long conversations with Mr. Shepard about what had happened on this incident, he is deeply remorseful, he's embarrassed, and he's ashamed of his actions. He acknowledges that his actions were a terrible choice that could affect not only his livelihood, but also his relationships. Ultimately, around this time, I know he was going through some financial hardship with family, but he doesn't want to make any excuses with regard to his poor choice here. Ultimately, Your Honor, he has no criminal history. He lived a law-abiding life before this incident. He does have 2 children, one with special needs, Your Honor, that requires a lot of medical appointments and special attention to. He is a very active father in his children's lives with that respect. Ultimately, Your Honor, he's been gainfully employed for 7 years. He works for Penske Logistics. He has a CDL license that he uses and maintains for 13 years. With that, Your Honor, I did submit several character letters on his behalf to show his familiar support. I know his fiance is sitting in the back of the room.
Familiar or
with him
familial?
to show support as well. Additionally, Your Honor, on his own, he did complete a theft class. A certificate has been provided to the court as well.
Didn't steal it?
Your Honor, we're just asking for any type of leniency with regard to sentencing today. Thank you.
All quiet in the Minecraft court. Minecraft court because of what's behind me. The pixelated jury box. Makes them look like Minecraft characters.
Mr. Shepard, what do you want to tell me before I sentence you?
I'm ashamed of what I did.
Why'd you do it?
There's no excuse for what I did, Your Honor.
I know that, but the question is, why'd you do it?
At the time, it was my financial hardships, being put on child support, and just struggling. They was trying to make it better, but
so what were you supposed to get out of this whole thing?
Vivian, you are an OG.
I'm supposed to get money out of it, but
how much?
There was never no set amount.
When did this plan get hatched?
That week, the 24th or 23rd, the week after, my brother had called me about it.
23rd of October?
No, November.
Wait a minute. This $114,000 in silver bars was stolen on November 11th.
Whoa!
8th, November 8th of 2024.
That was I don't remember the exact day.
Okay, that's a date.
Okay, I'm sorry, I don't remember that.
So how far in advance of November 8th of 2024 was this plan hatched by you and your brother?
It was that week.
That week. And tell me about the planning. Tell me how this whole thing unfolded.
He called me earlier in that week, maybe like a Monday or Tuesday, and he said that, he had a way to make some money. And at first he didn't tell me exactly all it was. And he said, "You want to make some money?" I said, "Yeah." Then throughout that week, he had told me like he got to put some stuff in play. And I said, okay. And then when he came up with the plan, he told me what we had to do and what I had to do. And
what did he tell you had to do?
He said I had to come up to where he worked at. And he said, come in, it'd be a box on the floor and just grab it.
Box on the floor where?
Inside the warehouse.
Okay.
And he said,
what did he tell you was in the box?
He didn't.
How big was the box?
40 kilos.
Maybe 3 feet wide, 3 feet long.
Okay. And what did he tell you you were supposed to do with the box?
He just told me to take it to his house. I didn't know what it was until he told me when I opened it. And he told me to take it to his house. And I don't know what he did with after that.
Okay.
And I asked him, he said, don't worry about it.
This has to be like a
Don't worry about it.
100-pound box.
All right, fill in the gaps for me, okay? Because
Kilo runs
you
about $2,800.
are 30 at this point. When this happened, you were what, 36?
Kelly.
35?
Kelly, congratulations on the new job.
36 when this happened. With no criminal record of any type. Okay. Working as a commercial licensed driver
Yes.
for Penske.
Yes.
Has your brother got a criminal record?
Yes.
How bad of a criminal record does he have?
How many pages?
I know he has DUI, and I know he's been arrested for, if I'm not mistaken, drugs. I'm not too sure on that part, but
Okay.
I know definitely the DUI.
All right, so he's working at Con Selmer, and just out of the blue, a couple days in advance of this, he tells you just to go into the warehouse, get a box, take it to his house, and you're telling me you have no idea what's in that box at the time.
At the time, I did not know what was in the box. I didn't
Why weren't you more curious, somebody with no criminal involvement ever, why weren't you more curious about what you were getting involved in with somebody you know that has a criminal record?
Could have been a
Why?
snake.
Normally I would be, I don't know, trying to trust my brother, but it was bad on my part to even do it. I shouldn't have. Like I say, during that time, getting the news, I'd be put on child support and being holidays coming up. There was no excuse for me to do it.
So, but you had no, you guys didn't talk about how much you were going to get out of this and how much he was going to get out of this?
When I asked him about it, he told me he had to see what he get for it after I found out what it was.
Okay. But you didn't know what it was when you went in there and tried to load this box into your trunk?
I didn't know what it was, so I opened it and I asked him what it is, and then he told me.
So when the box was too heavy,
100
because there
pounds.
were
40 kilos.
heavy silver bars in this box, then you called him, right?
We were on the phone.
Right. You were on the phone the entire time?
Yes.
For 9 minutes, right? 9 minutes, trust me.
I don't know the exact time we were on the phone.
All right. Talking about what?
When I went in there, when I got there, he was trying to tell me like what to watch out for. He was telling me like it's gonna be somebody riding around a tow motor, and that whoever's in there he was working with, he had them stay clear of the area. Then he was like, it was somebody in the lunchroom, but don't worry about that, they on lunch. And he said, just come in, grab it, and go. And then when I took the box out to the car, I couldn't get in. He was like, he told me to go back inside the building, try to find a drill or something. And then I know I had like a screwdriver in my car, and I unscrewed the box. And
Did you know when you opened the box, did you know what you were looking at?
when I opened the box and see, that's when I asked him, like, what is this? And that's when he told me what it was.
What did he tell you it was?
He said it was silver.
Silver.
Stamped, traceable
How much did
silver
you
bars.
think that was worth?
I didn't know how much it was worth. I really don't. I didn't think to ask how much he thought it was worth.
Now you know how much it was worth, right?
Yes, now I know.
How much?
Well, I was selling it $114,000.
Right.
Mm-hmm.
Where is it?
I don't know what he did with it. I took it to his house. I don't know who he gave it to. I asked him about it several times. He just told me, don't worry about it.
When did you go to the license bureau and get new plates?
That following week.
Why?
He had told me to do it. He was like,
Okay.
get rid of your plates.
All right.
Yeah, because that's not traceable.
When's the last time you talked to him?
The day before I got arrested.
Which was when?
Are there any mistakes yet?
It was a Wednesday. I think that was the 23rd or 24th of June
Of what year?
this year, 2026.
So you'd been talking to him up until that point?
Since the incident, yes.
Old time
And
gamer, thank you for the gifted membership.
Did you say, where's my money? Where's my cut?
I've asked him several times. He said that the guy that he had been dealing with, he said one time he called him, he said he was out of town. And another time he said he'd call him when he get back. I guess the guy gave him a runaround.
Or at least your brother's telling you the guy gave him a
Yes,
runaround.
my brother's son, yes.
He still trusts the brother.
So if as of June, it appears your brother, if he's being honest with you, which I doubt, but
I doubt because
if he's being honest with you, still had the silver, right?
that he still has it. Yeah. Or he knows who has it.
Right. So how are these people going to get their $100,000 back that was stolen from them?
If I gotta work it off, however, to get it back, I will.
Got a nice car now, so I can get a job. I'll take the Benz.
So what do you want from me?
Show me leniency, grace.
Why? Why am I going to show you? The Consumer had $114,000 of silver delivered to them to make instruments.
There's for some kids, trumpet.
You and your brother just felt like you were entitled to steal it. Now, I think that plant is closed, if I am correct.
That location, yes.
That location is closed.
Oh, I'm not sure.
Well, I'm sure. Okay, I'm sure. Okay, meaning the people that were working there are no longer working there.
They went out of business.
Now,
They went
it may
under.
very well be because they're out $114,000 because of you. And listen, I'm having a real hard time believing that you went into this thing without some sort of deal, without some sort of knowledge with your brother. Otherwise, why would somebody who's got a perfectly good job and no record, all of a sudden, what would possess you, somebody with that mindset, to walk into a place, a closed building, right? Was inside a building or was it outside the building?
Inside, but it was open.
Okay. What? Didn't you? Where do you get the nerve to walk into a building and steal something? Steal a 3x3 box with something in it?
It was stupidity on my part.
I know it was stupid,
Yeah, we
but it
know
wasn't. No, it wasn't stupid. It was thoughtful, is what it was. So you telling me that you were going to get money, this was the plan a week before, you telling me you didn't know what you were stealing, I'm not believing that. I don't believe that.
I understand, but it's the honest truth. I did not know what was in that box until I got there. That's the honest truth.
Okay.
When I opened the box, I asked
Now,
what
if you were an accomplished thief, then I would believe that, because it doesn't matter what you steal. You steal something, but I don't believe you. I don't believe you have limited knowledge of the plan beforehand, and the fact that you changed out your license plate tells me a lot. Okay, because why would you, other than him, when he said change your license plate, did you say why?
He had to say just in case you got caught on the camera.
Okay.
That's what he said.
And you said what camera, right?
Yeah, I did. He had told me there's a camera outside the building, a camera in the parking lot. He was like, change it just in case they caught it.
Okay.
Just in case. You were the star of the show on the camera.
And where do you work?
Penske Logistics.
Not
What do you
anymore.
Deliver tires to Firestones in the Cleveland area
How much do you work?
5 days a week.
How long have you been working there?
For basically 7 years.
Threw that away.
And you just pissed that all away to get a couple of bucks.
Well, that's one way to say it.
If I were you, I'd be pissed at my brother. And he's got $114,000, and you got zero. And you're standing here, and he ain't. So you started to tell me what you wanted to tell me. Go ahead, continue on.
This whole situation has been, I shouldn't have did it in the first place because it's not who I am. I'm not the person who did this.
Well, if it's not who you are, why are you standing here?
Because I made a terrible choice. I made an ignorant choice. Thinking that it would give me some type of financial gain that didn't. I shouldn't have done it in the first place because it's not me. I'm not no bad person, I'm not no criminal.
Well,
I feel like a failure.
You are a criminal because you stole $114,000 worth of silver.
All you did was set your price.
So you've made yourself a criminal.
You're right. I made myself a criminal with my actions. But it's one mistake, and I should have never done it.
One
That's
mistake.
not who I am. I'm not that type of person. I made a terrible mistake in judgment. I should have never.
When did you realize you made a terrible mistake?
The day I did it.
Okay. Then why didn't you, if you're not a criminal and you just made a terrible mistake, why didn't you go to the police?
I don't know. It didn't cross my mind to tell them myself. Maybe I should have, but at the time it didn't cross my mind. But
Maybe had you done that, Con Selmer wouldn't be out $114,000.
Maybe the plant would still be operating. People would still have jobs there.
Should have done it at all. None of this would have happened. I wouldn't be standing in your courtroom today.
I don't know, somehow $114,000 in silver bars has magically disappeared.
I don't know what he did, who he gave it to.
Well,
all I know he benefited from it definitely because he was able to start his own landscaping company out of it.
When did he do that?
Early last year.
Early in 25?
Yes.
So he got rid of it right away, right?
From what he told me, I'm assuming that's what he did. What he told me, he did that for money from working at kind of something, but I believe he did it from the stuff I got from his job.
Okay. Did you say when he opened up his own landscaping business, where's my money?
I asked him several times, like, yo, am I getting anything? All he kept saying, I'm waiting on the dude to get back at me. I'm waiting on the dude to get back at me.
$40 kilos of silver. Ninnis, sorry it's been a rough day. Welcome.
Where do you live?
Richmond Heights, Ohio.
Who do you live with?
My girlfriend, she's with Chisholm.
Who else?
And my son, Ayden. And my daughter was with me a few days out the weekend, every other weekend.
Right.
So look, the brother got away with it. No evidence pinning him to the crime.
What else you want to tell me?
I apologize, Your Honor, for my actions that led me to be here today.
When did you talk to the police?
When they arrested.
When I got arrested?
Well, when is the first time you talked to the police?
A cop or a detective called me back in May, and he said he wanted to talk to me, and he said come in or call him when it was convenient for me. That was like the first week of May.
And it just never was convenient?
Then you never called him, right?
I couldn't remember his name or his number. Because when he called me, I was at work.
But Judge, show me some leniency. I'm not feeling sympathetic.
Did he call you on a cell phone?
I don't know where he called me from. I know it was a 440 number. That's all
Did
I
he
know.
call you on your cell phone?
Oh, yeah, he called me on my cell phone.
So
Yeah.
you knew what the number was?
I can't remember what the number was.
Well, it comes up on your cell phone, doesn't it?
He just came up 440. That's all. He came up Ohio. He didn't say nothing like police or nothing like that.
Yeah, but when you talked to him, he told you he was from the police, right?
He said he was.
So you didn't talk to him because you didn't want to talk to him.
No. I really couldn't remember his number.
Okay.
Right. There's another thing we're going to add to the I don't believe it pile.
If you went to your history, you could have hit the
Leona, thank you
number
for the uncle.
It would have rang wherever he called from.
Yeah, but I didn't. I couldn't remember his number. And I could get a lot of calls. And during that time, too, I was getting calls from...
Did you get concerned when the Eastlake police called you after a year and a half?
I was always concerned.
Did that alert you to do anything?
A few times I thought about going, turn myself in, and tell them what happened.
But you didn't.
Just never crossed my mind. Other than I was always thinking about it.
Anything else you want to say?
I apologize, Your Honor, for my actions that led me to be here today. My actions did not define who I am. I'm not the type of person that did what I did back in 2024. I'm a good person. I made a terrible mistake. Family man, take care of my kids and go to work.
But what you call a mistake, I call a conscious decision to take other people's stuff. And the result of that seems to be that the people who work there no longer work there because that place don't exist, in part due to this. So this doesn't affect just you or your girlfriend or your kids. It affects several other people who no longer work there. I don't even think that's dawned on you.
No, I didn't know that it was closed until today, but yes, it dawned on me now what was all affected, yes.
Okay. All right, have a seat. I want to see you too.
Judge asked for a little chambers meeting with the lawyers. We're going to hold tight for that. Judge points out that what the defendant is calling a mistake, he says, is a conscious decision. Let me tell you what a mistake is. When you're in the grocery store and you're pushing a cart along and you've got your purse or your wallet, whatever, your man purse in the cart there with you as you're selecting groceries, and you go down the aisle, there's another cart, and you're choosing something from the aisle, and you absently take it and you put it back, put it in the cart, what you think is your cart, and you start pushing it, you're walking away with somebody else's cart and their purse. That's a mistake. Oops, I took the wrong cart. I left my purse over there. I took this purse. That's a mistake. Driving to somebody's business and lugging 100 pounds of silver into your trunk and prying it apart and throwing the bars in and giving it to your brother and asking for your cut is not a mistake. That is a criminal conspiracy. And that makes you a criminal. I mean, what else would you have to do to qualify as a criminal? If you were aspiring to be a criminal, right? If you're seeking that designation, what would you do that would make that? I do hear bells. I hear bells and trains in this courthouse. It's not like you have to submit your actions to some board of review and they're like, yes, we now designate you a criminal. Congratulations, welcome, you're one of us. No, all you have to do is commit the crime. It helps if you do it knowingly, and quite frankly, you did it knowingly. Saying I didn't know if it was silver or titanium. It doesn't matter. You knew it wasn't yours. That's what something you knew. Man's purse is called a merce. Okay. I don't have one of those. I have a very dilapidated wallet. It's falling apart. But it fits so well in my pocket, I just can't. Also has no money in it, but that's normal. My wallet never has money. It's just carrier for the Blockbuster card. Oops, daisy, I accidentally happened to put 200 pounds of silver in my trunk and drove off. My bad. Yeah, and then I thought about it for 2 years because I was always worried about the cops catching me. So I thought about that for 2 years. But I never crossed my mind to say, hey, I made a mistake. Officers, I need to tell you what I've done and point you to where the silver is. The older the wallet, the thinner it fits.
All right.
The more kids you have, the thinner the wallet.
Thank you, Your Honor.
I just happened to change my license
Court
plate
is
for
well
the next
aware,
week.
November 8th of 2024, defendant went into Conselmar without permission with the knowledge of where to go to get the silver that was taken. That knowledge came from his brother, co-defendant,
Insider,
who was working at Conselmar at that time. So they were able to work together to get the items, know where the item was, get it to the vehicle, and leave. This defendant is the one who came in the vehicle, actually took the items, put them into his car with a struggle since they were over 300 pounds of silver. Had to take it off the pallet that it was on to get into the vehicle. The license plate was bent on the vehicle at the time, so the cameras at Conselmar were not able to get the license plate, but law enforcement was able to look at various details on the vehicle, so they were still able to locate it on Flock.
I was going to say, thank you, Flock.
The vehicle was registered to.
Why was your license plate bent?
You can't deny this one.
He had told me to, Tracy had told me to take it off, and I didn't. And he was like, well, bend it. So,
You bent it to avoid detection.
yes.
Okay, go ahead, Ms. Cutts.
The law enforcement continued to try and follow the vehicle's whereabouts on Flock. However, it stopped hitting by the license plate. After a period of time, officers checked again the vehicle registration and found out that a license plate had been changed out within days of the theft. It was considered a non-mandatory plate replacement. Officers continued to investigate,
Meaning it was elective.
determining if the Jason Shepard that the vehicle was registered to worked at Conselmar. That's how they got to the co-defendant, Dwayne Shepard, and through Flock, through Conselmar's videos, phone records, all of that information, they were able to piece together and identify the individuals, because this defendant made sure his face was not seen on the video as well. And then Dwayne Shepard, who was supposed to be in Conselmar, did not cover up who he was in that situation. So the amount of the silver bars or the HSA anoids was $114,353.18. So obviously Conselmar did suffer serious economic harm. Their deductible was $100,000, so they only got back $14,353.18 from their insurance. So they are out $100,000. Obviously this is part of the organized criminal activity. Obviously the defendant has confirmed that, as well as our understanding of what occurred was already consistent with that. They clearly did it together. As this court has pointed out, and the state realized as well, in the pre-sentence report, the defendant does call this a horrible mistake, and the state is in agreement that this was not a mistake. that it was a choice, that he did choose to do this. We agree he does not have any known juvenile adjudications or adult convictions. His last traffic offense was in 2016. He also doesn't appear to have any drug and alcohol issues or mental health issues. So this was just a choice made to benefit himself. It is hard for the state to believe as well that he hasn't received any benefit and that he seems to indicate a lack of certain aspects of knowledge in this case. Based on all of that, prison is consistent. If this court is looking at whether he's amenable to community control, if the court were to find that, we do feel a significant jail time sentence would be appropriate. If he isn't sent to prison, he gets 5 days credit. If he is given that opportunity, we would ask for a decision point, community service hours, no drug and alcohol, screens, the restitution of the $100,000 to Conselmar Inc. Even though that location is not open, the company is still in existence. And no contact with Conselmar, as well as his brother, co-defendant Dwayne Shepard, costs. The remaining counts would also be dismissed. Thank you, Your Honor.
This wasn't a mistake. If it were a mistake, at some point when you went to Conselmar, at the very least, when you tried to put that box in your trunk and you couldn't do it, and you had to take the top off and then load the silver bars into your trunk one by one. If it were a mistake, you'd abandon that and gotten the hell out of there. If it were a mistake. It wasn't a mistake. It was a thoughtful, conscious decision that you made with your brother a week in advance of November 8th to steal that silver. And you can tell me all you want that you didn't know what it was or how much it was or what the deal was going to be. But if you went into it, you want me to believe you went into it on those terms, and I don't believe that. Okay? If it were a mistake, and you realize it was a mistake after you loaded it up, after you had bent your license plate to avoid detection. I'm not going to argue
about semantics here.
After you attempted to avoid having your face detected on the camera. Certainly when you got to your brother's house, was he there?
No, he was not, Your Honor.
Where did you put the silver?
He told me to put it in his basement.
In his basement. So you went in. How many trips to the basement did you make to unload this silver from your car to the basement?
3, 4 trips. He was right by the back door.
Huh?
3 to 4 trips right by the back door of his house.
How many bars were there?
I don't remember the count, how many it was.
Okay. If it were a mistake, you wouldn't have loaded that into the basement. If it were a mistake, we wouldn't be sitting here a year and a half after before your arrest. If it were a mistake, you wouldn't have ignored the detective's call. You would have called him back like you said you were. Okay. So this isn't a year and a half of mistakes. This is a conscious decision and effort to steal $114,000 in silver. That's what it is. You can characterize it as a mistake, but your decision had a devastating effect on this business and the people that worked at that business. I don't know that any of that's dawned on you because you're in the mode of feeling sorry for yourself because of what you face. That's where you're at.
I'm sorry, Coach. I'm sorry.
Go ahead.
It's not that I'm feeling sorry for myself. I fully understand what happened and what I did, and saying mistake is wrong choice or right. It was a choice. But I honestly, through this whole thing, when it happened, I honestly did not know what it was in that box until I opened it up. I didn't know.
And you should have said, holy shit, what have I gotten myself into? Right?
I did ask what it was. And when I seen it, I was like, what is this? And he told me, and he was like, you good, bro, just go.
I guess the judge is not happy with it.
It was a stupid choice.
All right, I've reviewed the
When this
pre-sentence
happens.
report and the letters that were provided. And I have listened to what you said, listened to what counsel has said, considered all the provisions of 29, 29, 11, 12, and 13. And with those statutes, there's various things at work as to what the penalty should be. So I've fully taken that into account. And I'm going to place you on community control for 5 years. You're going to serve 180 days in jail with credit for 5. Consider yourself lucky that it's not 18 months in prison with credit for 5. No drugs or alcohol with screens. Restitution to Con Selmer in the amount of $100,000. No contact with Con Selmer. No contact with Dwayne Shepard. Complete the decision points program and follow all recommendations. And pay the costs and supervision fees. Mr. Clement, any other terms?
Yeah, restitution.
You understand the terms?
Restitution?
Keep it. Can you repeat? I'm sorry.
Do you okay. 180 days of credit for 5. You cannot have drugs or alcohol and you'll be screened. You will pay restitution to Con Selmer in the amount of $100,000. You'll have no contact with Con Selmer or your brother. You will complete the decision points program and you'll pay the costs and supervision fees for your probation. Do you understand those terms? If you violate those terms, the state will file a motion to terminate your community control. If I find you violated, then I'll send you to prison for 18 months. Do you understand that?
Yes.
Is there anything else, Ms. Cutts?
Yes, Your Honor. Is the community control concurrent on both counts?
Yes.
And are the remaining counts dismissed?
Yes. Ms. Novotny, anything else?
Nothing further, Your Honor.
Oh, Your Honor, I apologize. You said if he violates 18 months in prison, there are 2 counts, both are 18
30
months.
months in prison.
36
There are
months?
2 4s?
Correct.
36 months. 36 months is the exposure if you violate.
You listening? 36.
All right.
3 years.
Unfortunately, that's what the sentence is. Down the road, we can file.
All right. He's like, I need a different sentence. Can't go to jail. I'm not a criminal. Yeah, you stole a small house. At least a small house worth of silver. That's a bad deal. Leona, once again, thank you for the Unk Alert. Appreciate the bits and tokens and jewels or whatever it is that get sent that way. Appreciate that. All right, we have another court to jump to. This is, we've been in Minecraft Court. Now it's time to go to Minecraft Court 2.0. Yes, they've got a new version of court. Let's jump there now and see what this hearing's about. I think I'm on the right one, Josh. Give everyone just a minute. This one's pixelated too, right? Yeah, the bottom's pixelated. It's actually a better Minecraft court. Larger pixels. One of those cases where the sequel is better than the original.
All right, we are present case 26 CR 000610, State of Ohio versus Alan Glavick Jr. We're here for an evidentiary hearing and the defendant's motion to suppress evidence.
Ooh, a suppression hearing.
Court with counsel Corey Hinton. State of Ohio is present, represented by Assistant Prosecuting Attorney Rocco DePiro. Any matters that we need to address before we get started here, Mr. DePiro?
Your Honor, Mr. Hinton and I have had discussions about the offer made in this case. And Mr. Hinton asked me to put on the record that pursuant to our discussions and at his request, I'm not going to withdraw that offer contingent on this suppression hearing. But Mr. Hinton is aware, and I'm saying it here on the record, part of the offer is that the state can revoke this offer at any time prior to acceptance being communicated to me. So I'm not going to make a contingent on this suppression hearing go forward, that offer, but I can still revoke it at any time before acceptance. So I'm putting that on the record here. And the offer is they would plead guilty to count 4, the theft, and count 1, the F4 theft, and the F5 complicity to theft. And the state's going to recommend prison. The defendant can ask for what he wants.
So plead guilty to count 1 and 2, dismiss the robbery charge or complicity to robbery charge and the criminal tools.
Yeah. And the state's can ask for prison, he can ask for what he wants.
Are those count 1 and 2 two separate thefts?
Yes.
One's at Willowick and one's at a different store? No?
Well, no, they're both at the Giant Eagle. However,
oh, one's the complicity to helping her.
Right.
And one's his own.
Right. The items that he stole on his own. Right.
I ain't still nothing.
From the east lake.
The Willowick Giant Eagle, Your Honor.
Oh, that's right.
But as Mr. Hinton asked me to put that in the record, so as a preliminary matter, I wanted to do that.
No, I appreciate that.
Sure. Thank you, Your Honor.
You discussed that with your client, Mr. Hinton?
Your Honor, as far as the offer staying open, I have not yet. That's a discussion we just had, but we had discussed the offer previously.
The offer that was just put in the record, you've discussed with your client?
Correct.
And he's rejected it at this point?
Correct.
But you understand what he just said, that offer doesn't stay out there forever. If the state decides 5 minutes from now they want to rescind it, they can do that.
Yes, we understand.
Okay. Counts 2 and 3 deal with allegations that he aided and abetted Henderson in committing theft and committing robbery, correct?
Yes, Your Honor.
What, I don't have the indictment in front of me, what's the count 4 of the alleged criminal tool? Is it the car or is it something different?
It's the minivan, the Dodge minivan, yes, Your Honor. And that will be the subject of part of today's suppression hearing, the minivan.
Well, but that's, you're alleging the minivan to help.
In furtherance of the theft-related charges here, all of them.
And the grand theft or allegations of his own theft that you allege he committed?
Yes, Your Honor, and the level of the offense is based on his having a prior theft offense as enumerated in count 1. But yes, and it was a matter of a couple $100 worth of merchandise.
So today's suppression hearing, if I'm understanding the allegations and correctly, deal with the seizure and ultimate search of the van, correct?
It's correct, Your Honor.
This is purely hypothetical. If I granted the motion to suppress, what would we be suppressing?
Would you like Mr. Hinton to answer that? It's his motion, Judge.
All right, yeah. What evidence it would be getting suppressed if you were successful in your motion?
Yes, Your Honor. As far as the evidence that we would seek suppress pursuant to the motion would be anything that was discovered in the van.
there's alleged stolen goods that were allegedly recovered in that van. We're citing and making the argument that the search of the van was unsafe.
No, I understand that. I guess I wanted to find out, if successful, what would the result be in terms of evidence suppressed? It would be the items found in the van,
correct,
which are the
I
subject of what count or counts?
If I may, Your Honor, those items that were inside the back of the van were returned to Giant Eagle. So the items themselves are not going to be presented at trial.
Well, but you're not allowed. He's talking about even the well, this.
So it would be maybe the body-worn camera that shows the inside of the van, or any testimony that relates to the officer's
Stuff found during this. I mean, it wouldn't relate to anything found just looking through windows or anything like that.
Well,
I guess that's a subject we'll talk about. But I mean, you're allowed to do that in a parking lot. But if that's what you're alleging, we'll argue that. But items, they're not going. They wouldn't be able to testify about items that they physically found in the van as a result of the search of the van.
That's my understanding of it.
That's what I was seeking, Your Honor. Correct.
What count or counts would that impact?
It would impact count one.
Just count one? Wouldn't impact the complicity charges, obviously.
It would not, no. And the possession of criminal tools, it would not impact
that either. So this
I shouldn't say it wouldn't impact it.
It would impact some of it.
Right. We wouldn't
some evidence that you're allowed to argue, but not necessarily observations that she allegedly got in there and he used it to get away and the sister in getting away.
The state would
but
still have
using it to conceal items that were stolen or something like that, it would help.
As to count one, yes.
So
all my stuff back.
So if
all my stuff back,
Mr. Gladwell, we're not going to do this today.
I know.
We're going to have this hearing, and I'll be respectful.
I'm just thinking about the whole.
I know, but you need to keep it to yourself or write some notes down if you want to.
Man, I got you.
So if successful, the only count that is potentially impacting is count one, and somewhat count four. You still have complicity charges.
It would impact it, but I would say, Your Honor, that the state would still have evidence to go forward on count one, yes, and count four. So it would not. Would not.
Let me see counsel real quick.
Yes, Your Honor.
Go on, Chamber.
All rise.
Little sidebar.
All my stuff back.
You can't stop talking. Can't stop talking. Just want my stuff back.
It's a joke.
It's a joke. I'm here for the hot mic. Hang on. Don't say anything now. You got 3 bailiffs waiting for you. Let's see if we can fast forward a little bit. Here we go. Looks like everybody's back. Just waiting for the judge. What does it say? Audio adjustments made here impact all viewers. Please adjust volume on your PC. They're tired of having people say, "Can you turn it up? Can't hear." Why are you peeking over his shoulder? Looking at the prosecution stuff. Zip ahead for the judge. You guys keep an eye out for him. If you see him, holler. There he is. Here we go. Stonehouse's member for 16 months. Just popping in to say happy Friday to everyone. Can't believe it's been 16 months already. That's awesome. Thank you for your support. Appreciate it. 16 months. Almost an OG. Very soon. All right, judge is here. Everyone be seated. Mic's on.
All right, we're back on the record, so I just want to clear my head. So, for purposes of the record, What evidence does the state have in regards to count one, the allegation of the defendant's own shoplifting, aside from evidence that was discovered inside the van?
Your Honor, the state has video recording of the defendant pushing, being inside of the Willowick Giant. Well, first of all, I should say, of his van pulling into the parking lot of the Willowick Giant Eagle shortly before he is seen communicating with the co-defendant Nicole Henderson in the lobby area. The defendant then goes into Giant Eagle, the main area of the store. Then we have video footage of the defendant pushing inside of Giant Eagle, pushing a cart full of items past cash registers and cashiers that are attending to other customers who are paying for their items. So that would be the points of purchase at that point. Where the defendant just walks right through the cashier stations, and then we have a video of him walking out the door, not having paid for those items. And that's on video? Yes, Your Honor.
And that evidence then is not impacted at all, even if I were to grant the suppression motion, that evidence is still coming in?
Yes, Your Honor.
That would have nothing to do with the search of the van?
That's correct. That would all be
You
prior.
agree with that, Mr. Hinton, correct?
I do, Your Honor.
Have you discussed that with your client? Or do you want a moment to do so? Or
If we could have a moment, I would appreciate that.
All right. Why don't you guys step out?
Yes, Your Honor.
I'm going to...
You're going to mute us, show us the screensaver, and we're going to wait for you to talk to your client for just a minute, who just wants his stuff back. How are you getting your stuff back from a store where you have to buy things? How does that work? How is it your stuff if the store owned it? It's not a pawn shop, is it? Here we go.
And we are back on the record at this time. Parties had a chance to, Mr. Hinton and the defendant had a chance to talk, and then the attorneys had a chance to talk. Mr. Hinton, I'll hear from you at this time.
Thank you, Your Honor. At this time, after further discussion and for various reasons, we would be moving to withdraw our previously filed motion to suppress evidence.
It's coming in.
Mr. DePierre, let me hear from you first before I confirm everything with the defendant on that.
Yes, Your Honor. Mr. Hinton and I have had further discussions here regarding the case and plea negotiations regarding the offer. The state understands that the defendant wishes to withdraw his motion to suppress at this time. Based on the defendant doing that and requesting additional time to consider the state's offer, the state agrees to extend the offer for the next 2 weeks. I will not withdraw that offer. So for the next 2 weeks, that offer will remain open for the defendant to accept. After that 2 weeks is up, I still may not withdraw that offer. It is going to remain open until I contact Mr. Hinton and notify him in writing.
But the earliest you would do that would be? Probably, I mean, look, today's the 7th, so the 21st is 2 weeks, so the 24th of August, I guess, would be that Monday after the next business day.
That's right, Your Honor.
And you're not saying you're going to withdraw it at that point, but you could.
I could.
But you're agreeing to leave it open, you will not rescind it at least until August 24th.
That's right, Your Honor. I will not.
Well, Mr. Glavik, is that what you want to do here today then?
Yes, right now, yeah.
All right, well then, the motion will be withdrawn. I'll do an entry just saying based on what was stated on the record, the motion's withdrawn. You don't need to file that. All right, thank you, gentlemen.
Thank you, Your Honor.
Motion withdrawn. Didn't get very spicy there, but it's fun to watch. I just want my stuff back. Let's see. Happy Friday to all of y'all. Excited for next week as we're in the jury pool for the Not the jury pool, excuse me. Not on the jury. Not disclosing anything that way. We are in the media pool for the Keefe D trial, which we're super excited for. Out of Las Vegas, it's going to be crazy. I was looking down the list of media outlets that are in that pool, and there's like 120 of us. And they're like movie theater, like movie production companies. There's all sorts. There's a lot of people in there. A lot of people are going to be watching this one. So let's. Oh, that's not the one. That's not the one. We're going right here. Let's go right here and see what's up here.
You owe me community service, 334. Millie, do you have a total for him now? 334. Is that all he has? Let's see.
That was 1 day credit, right?
Yeah. So 334. I think I got it. I think you owe 902. You want to just sit it out since you haven't got service?
Yes.
Have a seat. Let Millie get her totals right so I know for sure what to tell you is the time it would be.
Okay.
Millie, can you figure out his exact
He doubles
amount
up on
quick?
everything he says.
Yes, ma'am.
It's just that you printed those other papers. Did you know you printed to me?
Yes.
All right. Well, let's jump to Perkins.
Because of
And you address it, and you do it, and then what they have is they have all the outpatient and all the services that are there for you at times where we're not here and the court's not there, or that you can call and get some help. No, well, you might have to come in. You're gonna have to come in at some points. Well, that online stuff that you're doing, that NA and that stuff, I don't know. Aren't they going back in person now? Yeah, you need to go in person. That online stuff, you just sit there online. You don't pay attention until it's your turn to talk, probably. But you're coming in here with this, giving me this line of stuff. It's not working with me, and it's not gonna work down there.
Judge putting an end to that online stuff.
You have a good resource, but you're gonna force me to lock you up. Nobody, I don't think so. There he is.
Morning, sir.
Good morning. So we're going to see if he is eligible for drug treatment court. He indicated that he would mind talking to him.
Okay.
That's for the help.
They're on your way up.
Now, as for the case is concerned, I see that you may have some issues with that, and I'm sure they'll let you address those issues down there. Well, you can talk about that with Mr. Ogletree. You can talk about that with them, and because I see what Mr. Ogletree has presented as far as the issue that the case has. But in the meantime, you ain't even getting there if you're going to keep having these violations. And we're going to see what we tested them. He went down there and tested. We're going to see what that says today. But the drug treatment court, I'll forego anything if he's willing to get into the program. We first have to see if he's eligible for the program. Yeah, and I told him, this is, she will lock you up. But she's not just going to lock you up because, I messed up one time and stuff like that. That's not the way it works. It is really, she really wants you to be transparent. And I'm trying to give you a heads up before you go down there. Transparency is the case. You coming up and you doing like you're doing now with me, It's not gonna work. Anything, Ms. Lewis?
That's the best solution you can go to. If that's the best thing for him.
Well, I don't know what the best thing for him is to get the help that he needs. And that's what we're trying to provide for him. You know, I can send him to jail, he'll be out. I can send him up to 93 days in jail, he'll be out. And if he's out doing the same thing, what have we accomplished? But he comes in here with this, I'm just gonna call it what it is, the BS.
It's a good soundbite.
That's what he's coming in here with now. That's some very serious stuff. So I'm glad that you came. I'm glad. But another thing, he's telling me that he's taking care of you. You look like you can do it very well taking care of yourself.
He be helping me out if he need him.
I know you. I'm listen. You could figure it out if he wasn't though.
Right.
You know what I'm saying? You know that whole I'm helping my mom and dad out.
We can't do it. It's bad. It got bad. Then he can't hardly walk. And
I know. I'm looking at your mom, and I know your mom could do what she been around long enough to do what she needs to do and know how to handle her business.
Oh no, I don't. Look,
She's a lot of pain now. But if she, I'm not saying we don't need. Everybody needs help.
I am trying to look good.
Everybody needs help, but what you're saying, you're taking care of her. Yeah, you might be taking care of her. I think the more taken care of is still taking care of you. I think it's a little bit the other way around. Because you need to be working every day. DoorDash is not, I don't know if that's going to get it. Why aren't you working as a 9 to 5? Health problems? That prevents you from working a 9 to 5? All right, well, I won't go there. That's
his time.
Okay, I got it. Yeah, you did mention that. All right. Well, I'm glad you're at least willing to take the olive branch and get the help. Now you have to be. She's gonna come in. It's gonna be via Zoom. She's probably gonna Zoom in.
I told him that she was here, or that he was
and
here.
She's in person.
They said that they would send up either Warfield.
Or
like
oh yeah.
One or the other will be up.
Okay, good. So what they'll do is they'll come in. They'll get the information. They'll run it and see if you're eligible for the program. You have to be eligible first, and then they're going to go over the program. This is the time where you asked all the questions you need to ask. And I think we're here now.
We live here now. That's where we are.
Yeah. But another thing I'll say too is the very first step, and you should know this, is acknowledging that you have a problem. And the presentation that you made via Zoom, you didn't to me you didn't acknowledge that. You may have acknowledged that through your attorney, and he was trying to say that, but you.
Your chance to say something.
But you clearly said you didn't have a problem. You clearly said that. So after that, what are you going to do? Contradict what you say?
Puts you on the path to perjury.
And you clearly said that stuff is a lie. I've never had somebody violate as many times as that.
So whatever you're gonna say after you say I don't have a problem, now you're just trying to say what anybody wants to hear as far as I'm concerned. When you say you don't have a problem, that's what you said, right? I'm not putting words in your mouth, right? So that's the very first step. And if you can't get to step one, and if you've been going to those AA meetings, and if you can't get to step one, then it's not going to, whatever they do is not going to work. First of all, huh? No, you don't. No. You don't have to see. He doesn't have to. Hey.
All right. Can I talk to him briefly? But I do have a question in terms of court. I know you're referring to this drug treatment. That's normally after a person is found guilty or pleading guilty, but assessed beforehand.
Let's see what they say. If that's got to be if that's got to be the resolution, and he won't, and he can't go into the program, and he can't fight his case down there, then that's a different story. But now he wants to get it over with. I don't know. Talk to him, Mr. Overstreet.
It's funny, the judge was calling it like he saw it, and the parents were like, no, we need the help. Actually, he does help us. He is taking care of us.
Just came in the room.
Yeah, I see Officer Nelson.
Maybe the judge.
Good morning to you, Officer Nelson.
Good morning.
I think we're all done.
We're all done.
Outstanding.
Next
Second
person
back,
to
yes.
click the like button will be the
You say.
200th like. If we're all done here, let's jump up to Stevens. See how he's doing.
And all right, let's take up the matter of Devontae Jobert.
I just got 8 likes all at once. Thank you. You're all number 200. Look at this. We've seen people dress up for court, but this is...
All right, and you are Mr. Jobert.
Does
With
he have a
Chris Smith,
cummerbund?
your attorney, and the state's attorney is present. And in 23C 168, there is a motion to revoke probation that has been filed. Stand by, please.
Your Honor, I apologize for my appearance. I came straight from work. What's
We've
his
got
job?
two matters on Mr. Gilbert, right?
What's his job with that? A bellhop at the Four Seasons. I don't know what's his job to not bring the magic hat.
In 23CR168, there is a motion to revoke probation. In that case, as the defendant is on probation for evading arrest or detention with a motor vehicle since January 28th of 2025. That is a third-degree felony. He was sentenced to 10 years in prison, and that was suspended, and it was placed on regular probation for 10 years. And we have a new case, 26CR156, an indictment handed up by the grand jury on January 28th of this year, which alleges that on or about August 30th of last year, going on a year ago, that the defendant committed the state jail felony of operating a motor vehicle while intoxicated with a child passenger.
Oh, man. He took a bad thing and made it worse.
And the child was 5 years of age. Yeah. All right, let's see.
I think Judge Stevens instructs the lawyers that appear in his court to instruct their clients to dress very well. I don't think the clients understand what that means. Because I almost think that this is too much for court. I mean, if he wore like a big purple jacket with a feather boa, you know, that would be too much. Whose outfit are we discussing? I probably should have made that clear. It's the lawyer with the maroon tie, greeners. He's making the effort, but is it mocking the court?
Okay. Help me out on this. I'm a little fuzzy on what the plan is. Go ahead.
On the new case, the DWI, he's entering a plea of guilty, and it's an open plea to the court.
Open plea. Let the court decide the penalty.
And we're pleading true to counts 1, 2, and 3 on the motion to revoke. And we have
we're going to throw ourselves on the mercy of the court.
Witnesses to.
What is the agreement for the dispositions, though?
So the only agreement, Judge, that we have is that whatever you decide on the motion, that it's going to run concurrent with both cases.
That's right, Jeff.
The state is seeking pen time on the motion to revoke probation and state jail time on the new charge.
Okay. Let's deal with this motion to revoke probation first. It's the first in time.
Yes, sir.
All right. In 23 CR 168 of the state of Texas versus Devontae Corda Jobert, that is you, sir.
Yes, sir.
Present with Mr. Smith, your attorney, and the state's attorney. Does the defendant waive a formal reading of this motion to revoke probation? Can we proceed in summary?
Yes, sir.
And raise your right hand, sir. Do you solemnly swear or affirm any statement made during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. In summary, this motion states that on January 28th of 2025, so that's what, over a year and a half ago, in this court, you were sentenced to 10 years in prison, and that was suspended. You were placed on regular probation for 10 years for evading arrest or detention with a motor vehicle. Is all of that true and correct,
Yes,
sir?
sir.
All right. Allegation 1 states you committed the offense of operating a motor vehicle while intoxicated with a child passenger under 15 years of age on or about August 30th of 2025, which would have been 6 or 7 months after you were placed on probation, and that occurred in Jefferson County, Texas, and that is a violation of condition 1 of your probation order, which states commit no offense against the laws of this state or any other state or of the United States. It is also what is represented in this new indictment handed up by the grand jury in 26 CR 156 as of January 28th of this year. Is that do you understand what you're charged with here?
Yes, sir.
Is this allegation true or untrue? It is true. Are you pleading true voluntarily and because it is true?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant the motion to revoke probation? Your probation can be revoked, and you can be sentenced to no less than 2 nor more than 10 years confinement in prison.
Yes, sir.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Allegation 2 goes on to allege this motion to revoke probation that you were at a location other than your residence at approximately 1:08 a.m., which is also.
You have no business being out at 1:08 a.m.
It says,
at someone else's house, committing crime.
Violation of condition 19 of your probation order, which is be inside your home every day between 10 p.m. and 6 a.m. So that was 3 hours busting your curfew. What does the old say? Nothing good happens at that time.
Yes.
Generally. Is that true or untrue?
True.
And are you pleading true to that voluntarily and because it is true?
Yes.
1 and 2 are sufficient, Judge.
I'm sorry?
1 and 2 are sufficient. I know they planned on pleading to 3, but 1 and 2 are sufficient.
And once again, you are pleading voluntarily, knowingly, and intelligently to allegations 1 and 2, and you discussed all of this with your attorney, Mr. Smith, ahead of time, and voluntarily and knowingly made true to these 2 violations. That is enough to grant the motion to revoke probation, and your probation can be revoked. All right. Everybody has a position on this, and I'll ask the state can go first and last, and I'll ask the defense to also sound in Mr. Smith on the defendant's behalf, and the defendant can also speak. A couple of things I want to ask, though, if y'all will help me, that I'm not getting answers to from this file. According to the report, a blood alcohol test was made of the defendant. A sample was made, and it doesn't show in my file what it came back.
0.165.
165. Okay. Well, that's over twice the legal limit. All right, and also this public safety report that we have to determine. Has anybody seen all of this? Because I'm looking at the public safety report of the defendant. I'm going to make sure that everybody agrees this is what they understand. There was a Senate's report earlier made in this case. Do you have a copy of that? Because we urge that. Well, thank you, man. Okay, that's fine. Okay. And thank you. Yeah, this is what the public safety report from Department of Public Safety.
I do not have that.
The blue checks are prior convictions. And Mr. Jobert, you have a lot of prior convictions. How many?
I have 12 misdemeanors, 1 felony.
Is that your final answer?
Yes.
I think
missed some.
The public safety report reflects something different.
We're back to juvenile.
No, it goes back.
So I got.
But as a juvenile, you're unless you were transferred to adult status,
Okay.
then I'm not going to consider that.
I have 14,
Juveniles
14
can make foolish mistakes, and
14 misdemeanors and 2 felonies.
14 misdemeanors and 2 felonies. Do you think that's too many?
I know it's too many.
When did it become too many?
13.
After the first one?
Probably.
No, when I realized life.
No, first one. First one was good.
When I realized life.
How old are you now?
I'm 25.
Okay. Well, you've been an adult 7 years, right? 8 years. Okay. When did you realize that this doesn't help you and it's not in your best interest, and generally crimes come with victims, and we all, to live together in this country peaceably, are required to follow the rules so each of us can enjoy the blessings of liberty. Why do you keep making the mistakes? And here we are now, and out of all this, you've committed, after you made a promise to this court, and then within a few months, you're breaking the promise that you would follow all the rules by committing another crime that's similar. It's a traffic offense, and it's involving a child. And too often in this court, we have weeping and crying for mistakes made when people operate motor vehicles irresponsibly. They're nothing more than a 4,000-pound missile, and they do heavy tissue damage to people when they come into contact in a wreck. But you know that. And you know alcohol. I mean, you've got a child in the, how old was the child?
It was my cousin's son I was bringing.
No, it doesn't matter. It's a 5-year-old child, and you have a responsibility when you're operating a 4,000-pound missile, not only for you, the safety of others driving, but also the child passenger. My goodness. Didn't that come across of importance to you? Their life is in your hands, and you're over twice the legal limit of alcohol, which makes you unable to responsibly operate a 4,000-pound missile at that time.
Honestly.
There's an old saying, we come in third. Our creator is first. Others are second. We're third. You put yourself ahead of everything, which is irresponsible, but it's selfish.
Judge says, can I get an amen?
Selfless.
Little preaching from the bench there.
All right.
14 misdemeanors, 2 felonies.
They're along for the ride. They can't control what's going to happen.
Neither can you if you're driving drunk.
I think the court has put up what the boundaries here are. So go ahead. The state want to go first, or do you pass?
No, we have 3 witnesses that we wanted to testify for the court.
Go ahead. The state can go first. State can go first and last under the rules. Did you want to defer or put anything on, Mr. Hans?
I would like to open because I want to know kind of where my thoughts are on this before you start hearing evidence, Judge.
Go ahead.
Back when I had this initial case, what Mr. Joubert is placed on probation for, Your Honor has had an opportunity to remind himself of the facts of that offense. The facts of that offense itself is so disturbing. The evading arises out of some indecent exposure that was going on with him out at Lamar, and Lamar was actively looking for him involving those particular instances.
You're talking about Lamar University here?
Correct.
He was around campus, yeah.
And those are items he was found guilty of from that are marked there as August 23rd, 2022.
That report.
Where he where he pled and accepted responsibility for the underlying.
Do you need I don't have that book. Do you need this to refer to? Okay, hold on. Go ahead.
The underlying offense where he's running from these officers on August 23rd, 22 was because they were looking for a guy who was basically working his way around Lamar University and was picking up girls and showing them his junk in order to try to, I don't know, pleasure himself. I don't know. Bottom line was...
Hold on. You're shaking your head, but let me stop you. Let him, he has a chance to be heard, and you'll have a chance to be heard.
No.
But you were convicted of 2 indecent exposures, weren't you? You know what indecent exposure is? Okay. You don't get it for just taking your shirt off or taking your socks or shoes off.
The bow tie has to come
You
off
got
as well.
2 separate convictions here for indecent exposure, which means there were 2 different acts of indecent exposure. Let's see. The arrest date was
Where did this
February
come from?
23rd, and you were convicted. And what you get 60 days in jail on each of those, right? Okay, let him speak.
So on the day that this is happening, Lamar is actively looking for the person involved. He runs from the officers. That's the evading, which in addition to pleading guilty to the indecent exposure, he pled guilty to that as well. This is what the officers were looking for, was the person involved with those indecent exposures. Based on his history, having already been to prison twice before on separate matters, I had no intention of offering somebody involved in those facts and circumstances probation. I was convinced by Pastor Adolph to give this man a second chance. And I point to him in the courtroom because I know you're going to hear from him today. And it was through representatives of his that I went against every grain in my being to give him another opportunity. In my opinion, that experiment has failed miserably. He only made it 8 to 9 months before he committed a new offense, which he's pled guilty to you today. So just like the indecent exposure, he's guilty of that. Just like the offense that he's on probation, he's guilty of that. And what he's going to do is continue to offer excuses. You're going to hear from folks, and then probably after that, I'm going to show you, Judge, that at the time in which this offense occurred, he's immediately at that stage trying to convince the officer to let him go. He's already worried about this day in court. When all that goes to not work in his favor, and he's sitting in jail getting his blood drawn, that's when we see the true Devontae Joubert. I've got that video for you to see as well when it's my turn, Your Honor.
Okay. Now go ahead, Mr. Smith.
Mr. Joubert, let's talk about you.
He can ask you questions. Remember, you're still under oath, sir. Okay. Thank you. Go ahead.
Placed on probation back on January 28th, and there was a Ayden arrested. Could you tell the court to get this first off? Many times have you convicted of a felony?
Twice. I've been in prison once. He said I've been in prison twice.
So you've been in prison once. All right.
How many felonies? He said 2. You got 2 felonies,
one,
which are
one I'm on probation for. And
what
the robbery I went to prison for.
You've got a robbery conviction and then the evading arrest or detention.
Right.
That's on probation. Yes.
Okay. That robbery was back. That happened about. God bless you. You were arrested on 2019. And go ahead.
Now, explain to the court what the situation was regarding the Lamar University and all that at that time.
The situation was I was driving down Captain Street, and a Lamar police officer was going this way. I was going this way. They said they tried to pull me over, but I'm going like this. So when I get to the light, it's a red light. They have 4 police officers pass me up. The light turned green. I drive when it turned green. I turn on my street on Alabama, and I jump out my car and I say, "What's going on?" The reason why I pled guilty is because this man. He say every time we go to court, it's personal for him. Why am I personal to you? Every time I come to this courtroom, I'm standing here, I'm doing this. He's saying, "Oh, it's personal." Why do I got to be personal to you? I understand all this.
Wait. What? That's why you pleaded guilty?
Man, because I don't want to fight him.
That's not what you said under. Wait, hold on.
It's not what you said under oath.
Maybe you want to talk to Mr. Smith. You're digging a hole right now, because during the plea hearing you take an oath.
Right.
And I even asked you, are you pleading guilty because you are guilty? And your answer is yes under oath.
Yes.
And in the papers that you sign under oath, yes, I have committed each and every element of this crime. I am guilty of this offense and any lesser included offense. You're telling me today that, you know, we can't speak over each other. She has to take everything down and let me speak when I speak, and then you give a fair opportunity. See, you're not following the rules again, and it looks like you want to be in control. And here's the problem is you're telling me that you pleaded guilty for a reason other than contrition, and that you were guilty because of somebody else doing something, which is violating your oath. That's perjury. And I'm going to ask them to look into that because you're under oath now. But everybody who pleads guilty, if they're doing it and not following the oath, then they can be held accountable for another crime, because we don't want to make fiction here. We're trying to get to the truth.
Judge, if I may, this was brought up before. Mr. Ham asked me to independently look at the file, and I looked at it and concurred with his assessment of it. So it's not personal. It's something that we both believe is fair and just.
Well, but it goes down to what I make a decision over, and the paper is a document that you have sworn to that says, and I even ask you, are you guilty of this crime? Because you are guilty and for no other reason. You're coming up with something else. And that's perjurious.
The confusion, Judge, is that he's not talking about the evading.
He said I'm sorry, he said he pleaded guilty.
He was talking about those misdemeanors.
Okay, even that is the same
But that
thing.
wasn't before
It doesn't
you.
matter what crime, when you plead to crimes, it's all the same. You have to admit you're pleading guilty, not I'm pleading guilty for other reasons. That's so people later don't come back and say, oh, I want to change this now. And you have it, and you had a representation by attorneys, right?
Yes.
Okay, well, they know as well you can't be doing that. So that's why the truth is important, or else this is a farce. We try to get to the truth, but when you're
farce is
making a
strong
plea, you
with
don't
this
do
one.
it just for convenience. It's because you're accepting responsibility for your actions. So talking to me now about I did this for some other reason because somebody said something to me or something, that confounds the whole thing that you were on probation for. I mean, all that does is dig yourself a hole in more trouble. And perjury is a terrible crime. You've had enough crimes here.
Which,
follow the
do
rules
you remember which
and take
court
responsibility.
you made on those misdemeanors as far as
Running
the
to-
indecency?
Clinton Woods.
Huh?
Mr. Judge.
At the Woods?
Yes.
Judge Woods?
Mhm.
Okay. And, on that night of the evading arrest, I mean, were you guilty of going around and exposing yourself to women?
Yes.
Sir?
Yes.
And so that's why you
Yes.
did that. But after that, you accepted responsibility on the evading and were placed on probation.
Right.
Tell the court now what is.
Hold on, let me stop you just for a second. Why would you do such a thing?
It didn't go down like that at all. And it just being.
Tell the court what it did.
It's not.
How it went down.
Oh, great. It's about to go down.
I really don't even remember the whole situation.
I can't.
I just let it go.
What, were you drinking or something?
No. No.
Oh, you were sober and did this?
Oh my goodness.
Tell the court what is going on with your life now.
I've been out since December 17th. When I got out, when I was in jail, I said, I talked to myself and I got the same paper you guys got with all my convictions, all this, all that. Seeing my daughter come and visit me, seeing my mom crying, and I just made an oath to myself, hey, I'm done.
You have children?
Now I have a 3-year-old girl, a 5-year-old son, and a 6-year-old son.
Hold on.
I was sitting.
Hold on. You have a 6-year-old son?
Yes, sir.
Okay. But you still committed these crimes, some of these crimes while you had children at home?
Yes, sir, I did.
It's not enough that you can look into their eyes and see that your actions will affect them. And that when you do bad things, they're going to be adversely harmed as well.
Right.
And what is the greatest gift to your children?
My father, I feel like.
Sir?
My father, because I didn't have
No, your greatest gift to your children is to set a good example and to be a role model, because they're going to emulate what you do.
Right.
That's
takes
a
more than a
natural
flashy
phenomenon.
suit.
That's why you don't live just for you when you have children.
Right.
You live and you become third. The creator
This was
is
this
one,
morning.
others, your children second, and you come in third. That's selflessness versus selfishness. But here's the deal, you can always stop and act correctly and responsibly. Maybe this is your time, but for far too long, you have headed in the wrong path and made excuses, not accepting responsibility. And you did that today. But
on the night that you were arrested for this DWI, that you're pleading guilty to.
We need the soundbite. You're sober.
You told the officers that you had a couple of drinks, right? And you did not feel that you were really intoxicated until I explained to you what the legal definition of intoxication was. And so you agreed with me that technically you were intoxicated. You don't believe, we've had great discussions, we've talked to an expert. You don't believe that 0.165 is accurate.
Right, but I knew, after I spoke to you, I knew that I was physically not myself. So that's why I played to it.
Because you had lost some of the use of your mental physical faculty.
But I didn't feel super drunk.
So, when I was explaining it,
Go ahead.
we was about to show a video that night.
Go ahead.
The night I got pulled over, it's the same officer when I went to prison, and I had a conversation. I was a trustee in Jefferson County. We had a conversation every day he come to work. You know, when I used to talk to him and tell him, hey, this and that. And the night when he pulled me over, and I'll be honest with him because I knew him. He asked me, hey, have you had some drinks? I said, yes, sir, I have, you know. And he told me to get out, did what he had to do. I agreed to everything until he told me he was taking me to jail. That's when those videos come of me being belligerent, cursing, talking crazy because my feelings were hurt.
Because what?
Me talking belligerent, crazy, and everything because my feelings was hurt.
Your feelings were hurt.
Yeah. And so that's when all this come from talking crazy.
What do you mean your feelings were hurt?
So because me and him had a conversation and he used to always tell me, hey, you're capable of doing better. You're capable of doing this and that. And you're taking me to jail.
This and that.
But, you know, I cursed him out and did all that, went back and forth. But as soon as I got out of jail, I reached out to him, called, met him at the police station, apologized to him, told him, I understand how wrong you were doing your job. My bad. You know, I'm going to do better. And he accepted my apology, you know. But the thing is, he's trying to show this video that I'm just this guy. You know, but like I said, I went from, it took me to go back that time and see my daughter through this glass, crying, you know, and all this and that. When I got out, I started doing the right thing. I just got blessings after blessings, you know. I got a brand new house I just bought. I have contracts with Walmart.
Your new house, what is the address of that?
7895 Kemple Circle.
Is that here in Beaumont?
Yes, behind Papa.
Sorry.
And do you have your do you have your own construction company?
Yes.
And what's that called?
DJ's Redeemed Construction.
And as a matter of fact, concerning the construction company, you just finished a construction job at Antioch Church. Is that correct?
Correct.
And also, are you a manager of? You have a separate job of being a manager of Airbnb property.
Correct.
Okay. Are you also part of a non-profit organization that's called Dr. Biden?
Correct.
Could you tell the court what organization, type of organization that is?
So even though I'm going through everything I'm going through, knowing I gotta go to court, not knowing what's gonna happen, I'm still out there going, trying to talk to them and tell them, hey, my situation, I'm doing this, I'm doing it, you know, because at the end of the day, regardless of what happened, I know my heart's standing in this situation now. I know that this is my last time standing up for it.
But you still have to accept and deal with the responsibility of your mistakes.
I accept it.
Okay.
And on this evading that you're on probation for, that was not a high-speed chase. Is that correct?
Yes.
That was just explain to the court what
Was me driving to my house.
Okay.
As simple as that.
We weren't speeding.
No, I
anything of that.
nothing. It's I'm straight to my house.
All right.
Well, but hold on. But you committed the crime of evading arrest, right? It can be committed in ways other than speeding. Okay, because it's a 4,000-pound missile. If you're going 10 miles an hour, people aren't going to stand in front of you. You're going to roll over
I'm
them.
not saying I did.
You committed the crime. Okay, it may not have been egregious, but still, when the police have the lights, siren, you got to pull over and deal with it. Not on your terms, but on the law's terms. Okay. Go ahead.
So, in summary, tell the court where you think you are. Why do you feel that you're asking the court to continue you on probation? And why do you feel that the court should give serious consideration to that?
Because I don't usually come up here and talk. You know, what y'all do, what y'all gotta do, and I'm a silent, I'm gonna go about my day. I'm up here fighting for my freedom because I'm done. And personally, and I know this might sound crazy, I gotta point the finger to this man because he think I'm a felon. He think I'm not gonna make it. And I gotta point to prove I got kids, man. And
Wait,
like I
you said, what did you just say? You
got
have
kids.
Didn't you have children when you
Yes,
were committing these crimes?
I had to realize myself. It doesn't, I understand I have,
Okay.
but at the end of the day, I was just still caring about myself.
Okay, it's never too late, but you still have to pay the responsibility for committing the crime. Okay, all right.
Anything else that you want to add as to why you want the court to consider, continuing you on probation?
All I can say is I'm gonna let my actions speak for itself. I'm done. Y'all got me. Y'all got what y'all gonna get out of me. I'm done. Not gonna see me no more.
Okay.
You can imagine. I wish I had $1 every time I heard that up here.
That's understandable.
But just walk the walk. Don't just talk the talk. Okay. Go ahead, Bruce.
I've asked the witness.
Anything from Steph?
Yes.
Go ahead. Yeah.
Were you
drinking or something?
No.
All right, so let's try to do this in an orderly fashion. Yeah, that's the unfortunate side. When you decide to talk with the court, you have to also answer my question.
And it just being
Tell the court what it did. How it went down.
According to let's deal with this chronologically.
I can't.
Were
you drinking or something?
No.
Oh. You were sober and did this?
You have a juvenile history.
What is
The
going
reason
on
why
with
that's
the
relevant, sir, is the fact
Sorry, I had
is
to
in
grab some audio.
2016, you committed 2 felony offenses, theft from a person and unauthorized use of a motor vehicle, which resulted in you going to what's commonly known as TYC. Remember that? What you may not be familiar with is that underneath the law, that can and would be used against you as a felony conviction. Should have been told to you that back when you dealt with this when you were a juvenile. You understood that?
Yes, sir.
Okay. So you received a probation from this judge for the offense of robbery back in 2019. And that was revoked. And I happened to be the attorney on that whenever you appeared in court and you received 4 years TDC, correct? What?
It was revoked for what?
That's my follow-up question.
Thank you.
What was the motion? Do you remember on the motion to revoke as to why?
Yes.
Why you were revoked? What was it?
Because I didn't show up for my weekends and I had a whole bunch of theft charges.
Okay. And that was.
Can't understand why this keeps happening to you.
In 2019 was the original offense. You were actually revoked in 2021, right?
Yeah, because of Sean.
Right.
Because of who?
That was August of 2021. And then a year later, you're involved with these offenses that we've been talking about with the court, correct? Let's talk about that next. Yes. I'm showing your lawyer the PC affidavits for those 2 indecent exposures. These are court records, so they're admissible on that basis alone. Do you have any objections?
As those are official government documents, I cannot object.
But I would if they weren't.
Okay.
There were two different women, probably the state's exhibit 2.
However, I do object to the hearsay contained within.
Hold on. Now, what are you referring to?
These are probable cause affidavits on those.
On the 2 matters he's pled guilty to and got 60 days jail time.
Okay.
These are the indecent exposures.
Okay. Well, at the time, when the was a pre-sentence report made in that
On
case?
misdemeanor offense? No, sir.
But on this case, there was. On the evade.
Okay.
So I'm going to ask him 2 questions on that, and then I'm going to hand them for your review, Jeff. There were 2 different ladies involved with claiming that you exposed yourself to it. Do you agree or not?
I agree.
Okay. And these happened back on August 23rd, 22 there on Lamar campus, correct? Ms. Horn has said that she approached your car, you were sitting in the driver's seat stating, "Let me show you what you're missing out on," and exposed your penis to her.
I don't agree.
You don't agree? Second lady.
This is why we can't have nice things, guys.
Miss Menino stated that while you were driving, she glared over at you and saw you exposed your penis and you had began masturbating.
Why would she be in my car?
And then you stated, "I don't know, I don't know what you thought this was."
But the thing is, why would she be in my car?
You don't get to ask me questions.
But you can ask me questions.
Yes, sir, I can. Did you say that to the lady?
Yes.
And you were masturbating on that day?
No.
That all precedes the event where you are arrested and charged with the offense of evading arrest.
Okay.
Do you agree or disagree?
I agree.
He still thinks
That
this
those
is
2
happening
incidents
to
that
him.
the judge will read in the probable causes, that's the reason why Lamar was looking for it.
That's understandable.
Do you agree or disagree? Officers in this deal, despite what you said in the PSI, which went unobjected to, said that you sped off at a high rate of speed. Do you agree or disagree?
Disagree.
That you disregarded all stop signs and the safety of others in that area, including kids on the bikes.
Disagree.
They did say that you finally stopped at 400 block of Alabama Street. That's the one thing you agree with, right?
Yes, ma'am. But
So high-speed chase, what's the want?
Well,
can I say something?
Go ahead.
Why don't you, before you say anything, talk to
your
him
lawyer.
privately so nobody can hear you, so he can give you advice. Thank you.
Lieutenant.
Okay. What you just read all my criminal history. One thing that you didn't mention is I understand because it's your job about the gap in my criminal history. Therefore, what I mean by that is this: juvenile all the way to 2021. I didn't stay out 30 days. I was back and forth in jail. You catch me when you catch me. This time, motion to revoke with this DWI, I called my probation officer and told my probation officer, "Hey, I caught a new charge." I called you guys every day to see when I had a warrant for my arrest. They didn't have to chase me. I wouldn't turn myself in. So it's things that you're saying, and I understand it, but people change.
You're still committing the crimes, though.
You pled guilty to the offense of evading arrest.
That's cool.
I've stated to you for the record what the officers alleged. You're disagreeing with that.
We might need a bailiff.
No, I'm agreeing to. I pleaded guilty to evading detention in a motor vehicle. Because that's what happened. If they say I ran, I drove to my house, but I'm not pleading guilty to the things that they said that I did. It's a difference.
The 2 things I'm concerned with is that you were driving at a high rate of speed and disagreeing with stop signs.
No, sir.
You disagree with that.
I disagree.
But you pled guilty to the offense.
Because I evaded from him. I went to my house.
You know that you cannot legally do that, correct?
It's called illegal.
Sir?
You said I can't illegally do what? Drive to my house? If I'm nervous, you got 4 or 5 laws behind me.
That's the mistake that a lot of people make. That is not a proper thing to do in the law, sir.
That's understandable, but I asked you a question about the gap between my criminal history.
All right,
You're bringing up everything that I've been doing or what I have going on, and you're not speaking the facts that you know because you don't, you, like I said, you have a personal eye to me. I have recordings of you saying this on Robbie right here. This is personal to me.
pretty much what I have said on the record, and it's clear for the court's record, is that I do feel like when I gave you the opportunity that gave you this chance, and I said, I feel like I've got egg on my face. I do feel like I went out on a limb for you.
But then the day,
and frankly, Mr. Juber, it's not personal. What it is I do feel like you failed.
Right. But
so let's talk instead about the offense. Okay?
I'm not worried. We already discussed offense. What I'm trying to make clear to you is this, Mr. Ham.
Hold on.
That
Hold on. You don't get to decide how the hearing is. Please stop. It's you don't follow the rules. You have a fair opportunity to be heard. He, by his oath and his job, he can inquire. He's a prosecutor, and they can inquire representing the people.
Yes, sir.
And you may answer or not.
Yes.
And then Mr. Smith gets to put you on, and you can put whatever evidence you want. But you don't decide the way the hearing works. I mentioned that you like to be in control, but this doesn't show that you're really doing a good job on control and making the right choice. Which here's what's disappointing. I think you're capable of it. You're capable of success. That's why I'm frustrated that
you found a nice suit.
That you've had this many mistakes because you seem capable, and I hate failure. I hate failure, and especially people who are capable of doing better. He has a right to ask questions by his job, and you may answer or not, and the court gets to determine what weight and credibility is to be given by the evidence.
Can I talk now?
You don't get to control the proceedings. The state can ask and do its thing, and then the defense can, and then you have a fair opportunity to be heard.
So let's shift gears to August 30th. That's the night you were arrested for DWI with a child.
Right.
Have you watched the videos contained in discovery that's been provided to your defense counsel?
Yes, I watched it, and I explained to you because
I'm not asking you to go into an explanation.
Yes, I watched them.
All right. So hang on. Do you recall that the officer, after he placed you, or after you're talking to Officer Weeks right there at the patrol car,
right,
he leaves you there for a moment and he goes to talk to the passenger. Do you remember that?
Right.
Do you remember what he asked her?
Where did we go? Well, he didn't tell me what he asked her.
Right, but you've watched the videos.
He didn't tell me where he went. The only thing that I know, I was belligerent and I was acting out of feelings with him.
Do you remember when she told him that you were drunk whenever you showed up to pick her up?
Correct.
Do you remember her detailing all the amount of drinks you had before and after she got you?
Correct. I'm not saying I'm not taking responsibility for that. I did it.
And all those were different from what you told that officer that day?
Correct.
All right.
And I went back.
Second thing, isn't it true, sir, that whenever you realized that you knew this officer, that you were trying to avoid this whole thing, not be arrested?
Yes, sir. I was asking him, could I call somebody to bring me home? I'm not saying you're wrong. That's exactly what happened.
All right.
You know.
Did you watch the video that when your blood was being drawn at the gym?
Yes. Did you see how many times they stuck me?
Sir, well, how would you describe your attitude that day?
Belligerent. I was going crazy. I was in my feelings.
And what were you calling people?
Everything in the book.
And do you think that what your action was appropriate?
No, I know it was not appropriate. That's why I took the steps to go apologize to him like a man.
There was more than him involved.
Both of them and Roy Carroll got an apology from me.
What about the nurse?
The nurse, I spoke to the nurse when I went to jail for my motion to revoke probation. She's the one booked me in. I apologized to her first.
You were belligerent and offensive to Officer Weeks?
Correct. The other officer and the nurse.
Officer Tyler?
Correct.
And the nurse?
Correct. I'm not saying I wasn't. I'm telling
you. Not acting like you are today.
Because at the end of the day, I learned from my mistakes and I want to apologize to them. They accept my apology and we moved on with life about it.
I have no other questions, Ian.
I got one more thing.
He'll ask you and he'll give you the chance.
It's a statement.
Go ahead.
Mr. Ham, it's nothing against this. I understand you doing your job, but I'm not a failure, and I'm gonna prove you wrong. And regardless if I go where I have to go today, or the Lord let me go home, I'm gonna prove you wrong that I'm worthy of being on this earth and doing what I have to do as a man. And that's that.
Wait.
You and I have discussed.
Hold on. I'm a little. Hold on.
Wait.
Hold on. I'm a little fuzzy about it. What's he wrong about?
No, I didn't say he was wrong.
Well, he said you're gonna prove him wrong.
Because he said I'm a failure.
Isn't.
He said I'm a failure.
Well, you were failure on probation, is what he says. And by committing these violations that you've admitted to. Okay. Nobody's saying you're a failure. You're capable of doing great things.
Judge, you're more patient than I am.
Make those good choices.
Oh, sir.
Go ahead, Bruce.
You and I discussed on as far as what you were placed on probation for, the evading, that there is an offense called to elude, which is a misdemeanor, which is failing to pull over. When officers are instructing you to pull over, and you explained to me that is what occurred that night. You failed to stop when the officers were behind you, because you wanted to get to your house. But there was no high-speed chase, is what you're saying. Is that correct? All right. But after being, explained after you and I were talking about this, you agreed that technically you did violate the offense of evading for failing to stop.
Right.
All right. Is there anything else that you would like to tell the judge?
Like I just told you before, my actions don't speak louder than my words. He's done heard it multiple times.
What?
But if I say I'm done, I'm done. I got too much to lose right now.
Yeah. Oh God, yes.
It's honest. But
Are you supporting your children right now?
All my children stay with me.
All your children are with you?
Yes.
Are you supporting?
And that's at the new house, 7895 Kemper Drive.
Sorry.
All right. Is there anything else?
That's it.
Okay, I've asked the witness.
What happened on July 28th, 2026?
July 28, 2026?
Yes, sir.
Probation?
Yeah.
Okay, I went to probation. I went to probation, completed my MTRP class, went to do a UA, failed for alcohol, brought her my paperwork from my doctor.
That says what?
That said that this is promethazine that has 7 to 8% and will fail in the urinalysis.
Okay, so this is prescribed medication.
Correct.
And you presented to the probation officer the proof that this while you're taking this medication, if you were to take urinalysis, it will show alcohol.
When I first was sick, during February, I presented it to her, but she said she didn't have it no more. So I went personally myself because the urinalysis lady was arguing back and forth with me. So I made it to go to my doctor.
She was arguing.
And my doctor wrote a report saying that, hey, this is, this will fail. And I brought it to her, and that's what it was.
Because you had not consumed alcohol.
Right. I have not drunk. I got a breathalyzer in my truck that I blow in every day.
All right. So since I was the one asking questions.
Not a bragging thing.
Go ahead.
On July 28th, you tested positive for alcohol. It was after that day. You argued with it, and you said, I've got reasons. And you came back, and you brought them a medical excuse. That was done when?
Medical excuse was done February.
When did you bring it back to them?
The same day.
Right. You didn't have it on your person when this happened.
The thing is, this is already sent to her.
Sir, I don't want to argue with you. I'm just asking for a yes or no answer. You came back with the doctor's excuse.
Correct.
Right? I got it. You're saying that you had that before and you gave it to her before.
Right.
You're telling the court she told you that didn't happen, that she didn't have it, right?
Yes, she told me. I sent it in an email, a picture of the prescription bottle. But the lady that takes the urinalysis, she told me, no, it's an opiate. I went to my doctor.
Promethazine is, sir.
Not oral, not liquid promethazine, sir.
Right.
And I went to the doctor and the doctor printed out a paper and say, hey, they can say what they say, but I'm a doctor.
So your excuses for that incident is what you told the court, much like your excuses about indecent exposure the evading, and now the DWI with the
The
child,
thing about it is I'm not taking excuses. I'm taking responsibility for those.
with explanations.
That's not an excuse. That's exactly what happened.
Right.
It's not an explanation. I'm telling you I did it.
Yes, sir.
You trying to get me out of my character. I'm telling you I did it.
No further questions, Judge.
Anything, Bruce?
Nothing further. We have three witnesses that we'd like.
Okay.
We call Pastor Adolf.
How do you want to do it? You want to do it at the table?
Yeah,
Yes,
he can
please.
come up.
What can I say?
Let's all get comfy around the table. Let us pray. Just getting pastors here.
Raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hands. Go ahead.
For the record, sir, would you state your name?
My name is John Adolf.
Okay. And could you, for the record, could you also just tell us what you do for a living?
I am the pastor of Antioch Missionary Baptist Church.
And that is the same church that he just recently did some work on, construction work at your church.
That is correct.
Could you tell the court what your knowledge is of Mr. Jubert and what you would like to tell the court about?
Judge, I've been the pastor of Antioch for 30 years, and I've known Devontae for 28 of those years. His childhood, young ages of adolescence, young adulthood have been peppered with problems. His family sits on the same pew every Sunday, and I've watched him grow. I've watched him make so many mistakes. He has been the kid for me that we've always had to keep an eye on. Always had to say, but where is he now? When I ask for, grace and mercy towards him in his last condition, I just knew that he would be able to stay on the straight and narrow. The DWI that he had received was very hurtful to me. I was very disappointed. When I look at his past and consider that charge, my mind said, he's doing so well. It is why I'm in court today, because this is the best version of his personhood that I've ever seen.
Have you seen all this personhood? Because other people have seen
issues
more.
of honesty, transparency, integrity, and responsibility. Every time we talk, I say, where are you? What are you doing? How's it going? And right now, this is the greatest I've ever seen him as a young man. I think it has taken all that he's been through to get him to where he is today.
The court's decision today is to revoke his probation and put him in the penitentiary, or not revoke his probation, but continue him on probation and not put him in the penitentiary. What is your feelings about those choices?
Hold on. And there's a second case that
yes
is a felony and options of probation or
that's the DWI
or options as well.
What are your thinking? What are your thoughts about as to what he should any kind of guidance you give to the court as to what he should do with Mr. Jubert?
One, I think that if he's shown leniency, grace, and mercy, I don't think you'll ever see him again. I think that right now, I feel in my heart that he's the man that I've been praying he'd become. Get up, go to work, come home, love your wife, take care of your children. Where are you? What are you doing? And to move him forward. I don't think you'll see him again. I think he's reached a limit on whatever he's done before now. Will he be perfect? No. Hold on. I don't want to paint pictures of pseudo perfection. I think that'll hurt us all. At the same time, I do believe that he'll be in a lane that pushes him forward and really cause him to be a good, productive citizen. I believe that. When I check with him, I've talked to him almost every week. Right now, we have a little over 6,000 people at our church. And I've just taken him under my wing to say, where are you? What are you doing? And how's it going? Where are you working? How's your
big church?
How are your children? And what I hear from him consistently makes me feel like if we give him another chance, I don't think we'll see him again.
He'll be gone. Out of here.
Pastor.
Yes, sir.
I didn't realize you had a flock of 6,000 people.
Yes, sir.
I know you're a busy man. And I want to get, you and I have not one-on-one visited about this young man.
No, sir.
Can I ask you a few questions about indecent exposure?
First off, great book. Come to the table. When are you and Bishop Toops writing another one?
I hope soon. He's going to have an ecumenical gathering, and I will be away in Nevada in revival. I'll have to miss it, but I was hoping to be there. They changed the date. We had a date set for this wonderful ecumenical luncheon, which I think we are way overdue for.
Yes.
And no one could do it, I think, like Bishop Toops could do it, to just bring all of these denominational heads together, sit and talk about what we can do to make Beaumont great. And I was looking forward to it. So I don't know when we'll author the next one, but I hope it'll be soon.
So I mentioned...
Just, if I may,
yes, sir.
I hope that not only the prayers, but also that some thoughts to be given to help us, me and others in the criminal courts. We're the 21st largest county in the state with the 15th highest crime rate. And
Judge is asking for prayers.
Are busy here, and we can use all the help in prayerful guidance as we can give. So thank you for
a little divine intervention here.
Because this is not an evil county. It's wonderful. We've got a work in progress, and we all have a part to play in helping mitigate the crime.
I think we need to sing a hymn next.
The crime epidemic that we have.
Amazing.
There aren't many counties that have a proportion of crime based upon population that's high like ours. And we're working as hard as we can, and we need all the help. Spiritually.
Yes, sir.
I believe it works. So go ahead.
Thank you,
I too honor shepherds.
Thank you.
And I know that your flock is huge, and I know you do a lot of hard work. That's why I mentioned my shepherd was Bishop Toops.
Yes, sir.
It's tough when you've got that. And one of the things that you've stated,
now back to
there's several
exposure.
things that are ringing really close to my heart, and I want to go back to it. When did you start taking such a personal approach that you described to Mr. Smith with Devontae?
I would think when his mother came to me, and I don't know which one of those incidences it was on, according to that litany of things you all shared about his past, but his mother would come to me on a regular basis. We have prayer cards at our church, and people fill them out and they send them to me.
Prayer intentions.
Yes. And I would get one with his name on it. That's how I got to really know. His family would sit on the second pew to my right every Sunday, and there'd be these little boys sitting there. And so as they grew up, she would always tell me, please pray for Javonte. Please pray for Javonte. So it became just almost like a chorus. Pray for him, pray for him, pray for him. And her burden became mine. I don't really know the exact time or date, but that burden became something that I would take home, and my wife and I would pray for him.
Good. And obviously, no matter what happens, you'll continue to do that.
Absolutely. Hope things go better for you.
And we both can agree there's only been one perfect man that's walked this earth.
Yes,
sir. So the rest of us are just striving to do the best we can.
Yes, sir. Yes, sir.
You did not personally talk with me before I offered him the probation on this case, but you did have others come and approach me on his behalf.
Yes.
Correct?
Yes, sir.
And you know that efforts were made with your name attached to give this man another opportunity.
Yes, sir.
Were you advised that that was done with an extreme amount of reluctance on my part?
Yes, sir.
Were you advised it was solely because your name was attached to it?
Yes, sir. Yes, sir.
Wow.
Was it after that you started to watch him?
Yes, more so then. And to really try to make sure he was in worship on a regular basis.
Yes.
and to make sure that he was really barreling down on what he should be doing. Um, the evening of the DWI, should I say, the early morning of it came as a shock to me.
Right.
I was disappointed and shocked.
You described it as a disappointment.
Yes, sir.
I have that same thing, and you've heard the discussion he and I've had. I don't see him as a failure, but I see that as a failure.
Yes.
Don't you?
Yes.
I mean, because it was based on your words, your reputation, and the ability that he would follow.
Yes.
But he failed in that regard. He failed.
Absolutely.
Right?
Yes, sir. Yes.
Is there anything you could have done differently to prevent that?
Well, when I spoke to his mother about that very evening, he was just kind of wanting to just get away and to relax and just be with his friends.
Celebrating a recent graduation.
Right, right. So when I spoke to his mom about this incident, she said, Pastor Adolf, I cautioned him to stay. She said, but he really wanted to get away and just live for a minute. He felt like he just wanted to just be able to laugh and talk. And I said, I understood that. And I just wondered in my heart, in my brain, at what point was one too many? When did he lose control of that moment? I've always just thought about that. And I've cautioned him on it. My father suffered with alcoholism for 31 years. So it's one of the reasons I don't drink, because I know the demon that it can be.
I think we're getting the whole
just
sermon
often
here.
played it back in my mind. And I spoke to his mom about this on at least 3 other occasions before today, just talking to her. What happened, this, that, and other. And had he not gone, we wouldn't be here today. He'd be doing, just on the straight and narrow. Had he not gone, the video, because he mentioned that to me, he said, Pastor, I was really out of character on this video that they took. And I said, well, what I want you to do for me is be honest. Don't sugarcoat anything. Be transparent, be honest, take responsibility for that. And I just wonder what would have, this day would have never really been this day without that moment.
Can we agree that had he followed the rules of probation and ceased his celebration before 10 o'clock and gotten home, we probably wouldn't be sitting here?
Yes, sir.
And if he'd followed the rules, obviously we wouldn't be dealing with this.
Yes, sir.
Follow your advice, his mother's advice, we wouldn't be here. But he's a grown man and he made his own decisions. True.
Yes, sir.
All right, so let's talk about the second thing that you talked about. And I think you and I can both agree on this. It's important for a man to have integrity.
Yes, sir.
Do you think this man here has expressed integrity specifically in his actions just today in court when he's been arguing with me about doing my job? And
I think that he has been just to a push to be emotional. I think that he wants the truth to really come out. And it's so much layered. That's why I talk to him so much, because so many things are layered. It's almost like peeling back pieces of an onion.
So what layer are we missing?
I don't know if we're missing them. I think that right now, what I wish, we had the time to do is really figure out what really happened. Like so many times I want to ask him now, what happened with this? And what happened with that? And the story is always just layered, So I would reach to say that as I listen to him talk to me.
What do you play?
2 and 3.
What I would reach to say is that as we listen to him talk today, one of the things that I've really been pleased with is he hadn't tried to hide anything. I don't want him to hide anything.
I'll show you what's marked as State's Exhibits 2 and 3. These are the probable cause instances where on August 23rd, 22, he was using, at best explanation, a really bad way to try to pick up girls at Lamar University. One in which he exposed himself and told a young lady, this is what you're missing out on, and used the same line similar as he masturbated when he had another one in his car. Is that a man of integrity?
So,
did he tell you about doing those things?
I heard about the case at Lamar. I did not know about the intricacies or the intimacies of this man. No.
When we have integrity, we admit our mistakes and we come and we talk to it. And I don't want to get into confidences where you may have shared that information, but you didn't know this detail.
No, no. I knew about the case at Lamar University a few years ago, but I did not know about the specific allegations that are listed.
Thank you, Pastor.
Pastor, you heard this morning, and he's been make sure that the court realizes he's taking responsibility and he's telling the truth. And you heard him argue with Mr. Ham about the things that those two women, some of the things that those two women did simply not. And like even the officer saying it was a high-speed chase, he says that did not happen. I just did not stop. You heard him tell his version of what happened that night. Is that correct?
That's true.
And the thing that on the night of this DWI that he was celebrating, he had just graduated.
Yes.
He wanted to, and he made the mistake of being with his friends to celebrate that graduation.
Right.
And where he got his commercial driver's license and whatnot.
Right.
Which was a big step, for him.
A milestone for us.
That wasn't the mistake he made. It was operating a motor vehicle with a child. A child passenger while intoxicated. Not one, but two people were put in jeopardy there, and a child who just goes along for the ride. And it's our duty, our responsibility to protect them. You had two souls in that car. Yeah, go ahead.
Is there anything else, Pastor, that you would like to tell Judge Stevens that we haven't covered?
No, there's nothing else that hadn't been mentioned that I can think of that comes off the top of my head, other than the fact that I'm proud of you being honest today here. I'm thankful for you to be transparent, honest with integrity, and take responsibility for the things you need to take responsibility for. And in my mind, that's good Christian manhood. Stay on this street no matter what happens. This is the boulevard that I think you ought to be on. This is the street that I think leads to things that will lead you to favor with God. I'm very proud of that. I don't think you've tried to cover anything, mask anything. And I feel for certain in my heart that if we show him the type of leniency that I think that he could gain or possibly gain, that we won't see him again.
I have nothing, brother.
That's bad because he's on probation. We should see him regularly.
Thank you, Jim.
Anything at all asked to add by the parties?
Yes, I have what's called AJ Turner.
Confirm.
If you don't hurry, he's going to have to pay another day's rental on this suit.
And raise your right hand, sir. Do you solemnly swear or affirm the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir, Judge.
Please lower your hand. Go ahead.
For the record, sir, would you please state your name?
I'm Albert AJ Turner.
All right. And Mr. Councilman Turner, what do you do for a living?
I'm a city councilman, elected official, and an entrepreneur.
All right.
Wow.
Could you tell the court what is your involvement with Mr. Jupert and with the things that you would like to inform the court?
Well, I look at him like a little brother. He's a kid I kind of been mentoring on and off since he was in high school.
It didn't
often, I just rather be factual. We have young black men who don't have other black men they can look to that are guiding them, giving them the proper direction and showing them this is how things can actually be done. He literally sits 2 rows in front of me at church. And I remember seeing him start off at church by himself. But I also been seeing, as of lately, he's coming with his kids. And that really resonates with me.
And here, how long have you been involved with him?
Man, since he was in high school.
Okay. The man that he is now, I mean, you heard him testify that he just bought a new house at 7895 Kemper. He has his own construction company. In fact, he just finished a job at Antioch Church, and he's a manager at Green Properties, and he's highly involved in a nonprofit organization called Stop the Violence.
Mm-hmm.
Is this the man that the man that you see now? Is he a difference in the man that you've known in the past?
Yeah, but like most young men, I watch the cycle and the system, and I understand the way systems work. They get in trouble, and often one of the biggest things that I try to teach is accountability. I see people run from it. I see them make excuses. I even see them get emotional today. I almost wanted to get up and say, calm down. I literally wanted to.
Please don't touch
That's
the
why I'm
suit.
doing it now.
Hands off
But
the suit.
taking accountability is hard. And even people who you look up to, hearing some of these things about you are even harder because we pass a lot of judgment in life. So I think one of the toughest things for him is even me being in the crowd, hearing some of these things. But who I am, I used to be a parole officer. I try not to get caught up in who somebody was and I focus on who they're becoming. And I try my best to work with them to make the best version of them. But I do understand if you make mistakes, you have to be held accountable. So what I have seen him develop into, even him telling me he was ready to get married, I was kind of shocked when he gave me a phone call when he got his first contract at Walmart. You know, he called me excited about it. And I'm like, you know, just to see where I knew he was at, all the mistakes and things I knew he's done, and to see where he's going, it really shocked me, made me feel good about it. But when I heard about what happened, it was definitely disappointing.
And the man that you see, everything that he's doing now with his life and taking care of with his children and all of that, is that the type of man that you're convinced that if this judge was to see fit, would give him a second chance and allow him to be on probation, that we would not see him again before this court?
Yes, I feel good about it. But my biggest thing is, even for myself, I try to look in the mirror and I want my kids to look at somebody that they aspire to be. And that's what I want to tell them today, the way his kids look at him. If the kids knew some of these things, that mistakes he's made, you want to make sure you're making a proper decision so you don't discourage your kids or you can't be around your kids, because I see him love on them on Sundays. I see him hugging them. I see his arms around them, man. Just to kind of watch that, it's just tough to hear what's going on today.
Is there anything else that you would like to tell Judge Stevens in this decision that he has to make as to whether to put him in the penitentiary or to allow him to be remain on probation?
Well, Judge, it's hard to deal with these type of instances. Even the emotion he showed earlier. As I stated earlier, I wish I could have walked up here and said, calm down, you got it. But what I'm most proud of is when we talked about this, he said, I'm taking accountability. I'm not making excuses. I'm admitting to what I did. And whatever the results are, I'm just going to live with it. And a lot of people don't do that. You know, everybody's looking for a way out. And just to have the level of maturity to say, whatever the results are, I live with it. And me coming today was based upon what I've seen in his growth. You know, when you see a brother fall and is struggling, specifically brothers who might not have an older brother or a father figure, me as an older man, I want to grab him and pull him up. I don't want to leave him down there. People ask me to come speak often. I won't, because if I can't physically see you're making improvements and doing the right thing, the last thing I'm going to do is attach my name to that. So that's why I chose to come today, because I have physically seen it. I've seen the growth. I've seen what he's doing in business. I understand celebrating when you accomplish a milestone. But like Judge said, the celebration wasn't the issue. Choosing to drive the vehicle was the issue, specifically with a kid in the car. But you having kids, I definitely understand that as well.
Thank you, sir. I have nothing further.
Yes, sir.
Thank you.
I have a few questions, but before we get started, my memory is that, have I represented you in the past?
Me?
I'm just checking.
No, sir.
No, it seems like every time I'm confusing you with someone I dealt with, and to be fair, it's a domestic.
Yeah, I've never been arrested.
No, it wasn't criminal.
Okay.
I'm remembering a
The man's
domestic.
an elected official here.
No, if it's a domestic case, well before I ever came to the DA's office.
No,
All
not
right,
me at all.
good, fair enough.
Whoa.
If that was true, then I had to disclose it for the record.
Okay, no, not
That's
at
the
all.
only reason. All right. So,
He thinks he
second,
did.
number one,
On a domestic.
I appreciate you coming up and I take to heart what you're saying, that you take your name serious and you don't just throw it around.
No.
Brother, your reputation is something to be valued, and I appreciate it. When you talk about Mr. Jubert, your dealings with him is church, right?
Mhm.
Just
Church
like
and stop the violence.
okay, and you just like since Tommy Coleman's the only prosecutor in the courtroom right now, he and I know each other professionally. We work together, right? And I have my opinions about him.
Sure.
We see each other in work, just like I have friends in church. I see them in church. If I go to the gym, I've got friends at the gym, right? And we develop opinions based upon what we see during the time in which we see them, right? And
So he's a
based
good
upon
kid
what
in
you've
church.
seen, that's what you're giving the judge here today, right?
Yes, sir.
Today, did you learn about the indecent exposures?
Today was my first time learning about that. Yes, sir.
All right. It's not something shared in church,
No.
right? Were you aware that he went to TYC?
Yes, I was aware that he went to TYC.
Did you know that
he's been in and out?
He's been in and out of trouble. You've known that,
Yes, sir.
right? Did you know what he went to TYC for?
No, I know he's been in and out of trouble a lot. I don't know the specifics of every time he's been.
Did you know that he was placed on probation for robbery?
Yes, sir. I did know that.
You know that was revoked,
Yes, sir.
and he went to prison for that.
Yes, sir.
And it was within a year that he picks up these charges that placed him on probation.
Yes, sir.
And it's within a year after getting this probation that he picks up a new charge.
Yes, sir.
And yet you still have all that opinion.
Yes, sir. I still feel good about this young man.
Is there anything you could have done to prevent him from driving with it while intoxicated with a child in the car?
It's nothing I could have done. No, sir. I don't think it's nothing nobody could have done.
So are you aware that the lady that was the passenger in the car that day tried to talk him into letting her drive?
No, sir. I wasn't aware.
Do you think you could have talked him out of driving that day? Maybe you could have drove instead?
I definitely think I could have.
What greater ability do you have versus the lady he chose to spend the night with, who happens to be the mother of that child?
Men, and let me explain this to you when I say men, like a father figure. I know if I can look at a young man and I can convince a young man to do something, I also know I have the physical strength, if necessary, to stop a man from
I'm smiling because I understand where you're coming from.
Yes, sir.
If he wouldn't have listened to you, you would have made him.
Yes.
That's what you're telling me.
Yes.
Right. You willing to sign up for that for however long he's on probation?
Am I willing to sign up for what, sir?
Be there physically to make sure he does what he's supposed to?
Yes, I will be there physically for him.
All right. No further questions.
Anything else?
Nothing, brother.
Councilman. Thank you.
No problem. Thank you.
Anything else to
full-time
add by the
chaperone.
parties?
Yes, sir, we have, we call Gary Senegal.
Okay, who can this be? We got a preacher, we got the councilman. Now we need what? Is this the governor?
Come forward, sir. And please raise your right hand. You solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. Go ahead.
Please state your name for the record.
Gary Senegal.
And Mr. Senegal, could you?
Is it Senegal or Senegal?
Senegal.
Gar. Yeah.
AURGA.
Yes. And what do you do for a living, sir?
I don't do a lot. I'm president of Stop the Violence, father, grandfather, part-time Junior Rogers, truck driver, ex-correction officer.
Part-time meteorologist?
Could you explain to the court what is your involvement with this young man that we have here?
I met him while I was at the jail, and I watched him. I watched him change, and he actually got better. You know, as I saw him, and after he got out, he was a trustee. Came in as he was a regular inmate. Then I was known around the jail for talking to the guys, talking to some certain young men. You know, and I watched him. He actually changed. Listen to me. Had to pop him a couple of times, but he listened.
Had to pop him a couple times.
And the information that you've been sitting in the audience and the information that you've been hearing about what he's doing now in the construction company and several things that in this nonprofit organization stuff that you've heard all of that. Is that correct?
Yes.
All right. The of course the issue before the court is whether to put him in the penitentiary or to place him on probation. The man that you know that he is met, you feel comfortable making a recommendation that that the judge could allow him to be on probation, extended probation, and that we would not see this young man again before this court.
I stand on it because I listen to everything that he says that happened. I know about a lot of it, but I just want to say if God will allow some of our past transgressions to be read out loud, it would sound worse than that. You know, everybody in this room, yeah, hidden stuff. You know, it's just exposed, and it's not to make light of it. But like Albert said, a lot of these young guys, young black men, young men, they need the father figures. A lot of them don't have it. And it's not to condone it or to make excuses of it, but that's why I'm here. You know, I feel like I feel. You know, I have sons as well, you know, and sometimes they slip through the cracks, you know, but does that mean he's jailed or jailbird? Is he a convict? Is he an inmate? No, he's not. I've been in the profession. I've been in that business for a long time. And if I don't BS, I don't like to waste people's time. Time is money and it's time. If he wasn't that person, I wouldn't be standing right here. I would say, yeah, he belongs in jail. Jail is what's going to rehabilitate him. But he's not, that's not the character that I see. And thank you. That's what it is.
I don't have any questions for you, but I know you and I've talked on the phone before. I remember before you started the Stop the Violence.
Yes.
And I 100% appreciate everything you're doing for our community. So
thank you.
But the good work.
Yes.
And Judge will remember you testified last week. So you're making a habit out of this. When are we going to see you on next week? All right. Thanks, sir.
Last witness is Todd Broussard.
4 witnesses.
And please raise your right hand. Do you solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Please lower your hand, sir.
And for the record, sir, please state your name.
William Todd Broussard.
And Mr. Broussard, what do you do for a living?
A lot of things. Entrepreneur.
Okay.
Sales manager for Tees to Your Door. I run a nonprofit called the Mentorship. And
Mentorship?
I do Airbnb businesses. So that's what things is.
Could you explain to the court what's your involvement with the young man that we have before the court, Mr. Jupiter?
My knowing Devontae stretches back to I started substitute teaching in the district in 2010. I was working for Channel 4 before that as a media manager. Corporate did layoffs, so I resorted to the school. As I was in the schools, I met the young man in middle school. I'm going to say 2011 or so. He was a fighter. Yeah. He would get into it with kids at school, and I tell him, I said, you know, if you like to fight, you might need to go and get paid for it. You know, turn that into a business or structure any of that anger. We take it and push it towards something positive.
If you want to fight, you just get paid for it.
Little did I know, later Miss Regina Rogers
would take me down to Minnie Rogers, and I saw Monte there. That was my first visit. It was an eye-opening situation. So I'm like, man, I see so much potential. At that moment, I knew, and I'm gonna say at that moment, when we were in school, I saw the potential. So when I was brought there for that moment, I saw him, I gave him some urban words. He lit up, he lit up. Now, did he have his bouts? Was I there all the years? Well, we were back and forth. Of course, he served his time. But when he came back, this, I've never seen like this before. Never in my life have I seen him to this stature of a man before.
In this suit.
I can honestly say if, for one, the accountability, the upfront taking responsibility for his actions, first and foremost. I truly believe that if he was where he is today, he might have fought this case and possibly won. Financially wise, let me say that. I also believe that because of his truthfulness,
he would have fought and won
and taken accountability. He told me that then. I asked him, please don't sign for a 10-year deal. I asked him personally, especially it not being deferred. But he said, man, I'm going to do it. But he was also, again, frightened.
And that was on the probation.
That was on the probation that he took. That was my first time encountering Stan. But I will say this, and I will say this to you and your honor. Mr. Hammond and I had a conversation after he got the DWI. And he specifically told me, I have him in my crosshairs. And took that two ways. Took that as in, okay, I see crosshairs as in a scope, hunting, or I could understand coming from him being a prosecutor that, oh, I'm going to get him. So my request, and from what I see now, that this young man, regardless of what he has been through, regardless of the decisions he has made, I seriously doubt that you will see him again.
So the issue before the court is to whether to put him in the penitentiary or to allow him to remain on probation.
Yes, sir.
The man that you know now, the way he is now, do you think he is worthy of being given a second chance and being continued on and be placed on probation?
Yes, sir. I do believe that he should be in state of probation. I will also say this to Mr. Ham. The other conversation we had was about Paul, who also wrote Romans in the Bible, saying Paul went to prison. I get it. I understand. But he also wrote Romans 8:34. If God be for us, who can be against us? So, that being
Is
said,
there anything else that you think you need to tell the judge that would be helpful in the issue before the court?
we'll see you.
Thank you. Nothing further with this witness.
All right. So, no offense to the other three gentlemen that have been character witnesses. You've been with him the longest.
Yes, sir.
And the reality is that every time he's come to court, you've been here.
Recent.
All through this current situation, we've seen you every time.
Recently.
That's why we've had conversations.
I wasn't there, before he went to prison, so that's right.
But you were here when he took the probation deal.
Yes, sir.
And had anybody asked you and placed you under oath, that same day you would have said same stuff you said today, which is we're never going to see him again. He's never going to commit another offense. In fact, you told me that day.
Did I tell you that?
Yes, sir.
Yep.
You sure?
Pretty sure.
No, sir.
Okay.
No, sir.
You're under oath. We'll go with your answer.
Yes, sir.
You don't remember us saying that.
I spoke to you about, I said, if he is taken in our custody, and I
Yes,
said
sir.
custody, I'm sorry. If he's taken under our
Tutelage, your program.
tutelage,
Yes, sir.
programs, we're gonna mold him.
Yes, sir.
We're gonna mold him.
Did you do that?
Yes, I believe.
And was that before
Did it
this new
take?
offense?
Did it take?
That was the beginning.
Right.
Yes, sir.
But this happened anyway,
Yes, sir.
right?
Yes, sir. Man falls 7 times. Get back up.
Yes, sir.
Yes, sir.
As I
That's in the
said,
Bible,
with,
by the way.
with, as I said with Pastor, there's only been one perfect man that's walked this way.
Yes, sir. Yes, sir.
It's not any of us in this courtroom.
Yes, sir.
Right. Thanks, sir.
Anything else?
Nothing about this witness.
Thank you, sir.
I would like to ask my client, is there anything before we submit this to the court? Is there anything else that you would like to tell the court in closing?
Yes. To all three of y'all, I understand that. I'm done. You say, I know you say you heard it, this and that. Y'all not gonna see me.
Anything else?
That's it.
That's all we have to.
I have no questions of him, Judge.
What are y'all asking for? Stay.
Sir.
What are you asking?
I'm going to respond. I'm going to let him start, Judge.
Go ahead, Bruce.
General, on the new case of DWI, we're asking that he was given probation and that it run concurrent with the court allowing him for the court to extend his probation term on this evading detention, not revoke his probation and allow him to continue under whatever terms the court deems appropriate to remain on probation, and that's what we're seeking.
They just want probation, no jail, no prison. State?
My opinion hasn't changed, Judge. I appreciate and I love and respect the gentlemen that have showed up for your behalf today, Mr. Jubin. The harsh reality is that the original incident that got him started down this path that you're making this decision today on, those misdemeanors are just horrible. And Lamar was doing everything they could to try to find who was involved in that. And what I've witnessed today is the same thing that's continually occurred. It's a man who accepts responsibility in quotes, but offers so many different explanations and reasons why it's not as horrible as it sounds. But the reality is, it is as horrible as it sounds. He was wagging his genitalia at 2 different college girls in Lamar in 2022, less than a year after getting out of prison. We did not teach him a lesson.
I was not expecting that.
On good charactered men. I did not hold his feet to the fire. I did not seek his time in prison whenever he was up on the trial docket on this evading detention with a motor vehicle. And it is not like he keeps trying to tell the court. I remember the evidence. I know what the witnesses would have testified in the trial. There was a high rate speed where he did disregard stop signs. He put people at risk. It was a clean and clear evading. Yet he started probation. And not even 8 months later, he's in a vehicle, drunk twice the limit, with a lady who tried to talk him out of driving because she was worried about her child. We're lucky that we're not here on some kind of manslaughter charge, which Your Honor seen too many of. I can't in good confidence, in representing the county, recommend anything other than an 8-year sentence on the underlying charge, which is the evading. And I leave it to your honor's discretion as to what should be done on the DWI.
Anything else?
Well, just, I mean, Mr. Ham is putting great emphasis on those misdemeanors that occurred prior to you being placed on probation for, for this evading. And my client has taken, just a probable cause affidavit does not prove the allegations that Mr. Ham is trying to convince the court that is true, and he is in fact under oath denied some of the allegations, some of the statements that are contained in the probable cause affidavit. It appears to me that the state is wanting this court to revoke his probation and punish him for the allegations that are stated in those probable cause affidavits, and I would submit to the court that is not the issue before. He has been proven that he is a businessman. He's done work for the Antioch Church, of all things, and he's smack dab in the middle of being highly involved in a nonprofit organization called Stop the Violence. He's just simply not the same man that he's had in the past. He has been truthful with the court. He has taken responsibility. And this is a young man who I feel, if the court would give him the chance, that he would be successful on probation. You would not see him before. Yeah.
14 misdemeanors and 2 felonies.
Let me get I need some clarification.
Back to back.
The robbery conviction earlier, he was convicted. Was that 10 years regular probation in 2019?
Yes.
And was it revoked? And you were sentenced to what? 4 years. All right.
Here's the packet of information, Judge.
Well, there might be some jail time here, and then you can get it all behind you. But if this guy walks out of here on the good words of some influential witnesses, I don't think justice is going to be served.
All right. The evidence is before the court. The court has reviewed the court's file and listened to the evidence presented in the arguments of counsel and also the statement made by the defendant. In this first case, this motion to revoke probation in 23 CR 168. Okay, there's some changes that need to be made on the paperwork y'all fixed. Number one, it said prosecution will proceed only on counts 1, 2, and 3. He pleaded to 1 and 2.
Yes, sir.
All right, so I'm going to correct that.
No verdict music on this one. It's just it's a revocation hearing. It's the longest one I've ever seen, but it's a revocation hearing. That may be his going to jail suit.
And the agreement by the parties that the agreement is that whatever sentence in the disposition of this case is going to run concurrently with 156, that the defendant is going to be entering a plea of guilty to the state jail felony of driving while intoxicated, which was based upon the allegation in the motion to revoke probation, allegation number 1 out of the 2, the defendant pleading true to driving while intoxicated with a child passenger and also being at a location other than his residence after he was on his curfew order. Correct?
That's correct.
Okay. So this is there is some conditions based upon an agreement in this case.
Yes, sir.
All right. So If I follow this agreement, he has no right of appeal, but y'all mark through that, right? If I follow it, he's gonna, okay, y'all mark through this, which is.
On the concurrent, yes, sir.
Right. I'm gonna change that.
Yes,
He
sir.
has no right of appeal if I follow this, right?
That's correct.
Okay. It's reflecting otherwise, we gotta fix this. There we go.
Fixed.
Don't need to fill in at the bottom of that with the defendant and, yeah.
The judge appears to be
Gotta get it
preparing
right.
to accept the plea deal. Which would be probation. Surprised the prosecutor didn't ask, what can you tell the girls at the local colleges that will make them feel safe, knowing that we're letting this guy go?
Okay, on this, Mr. Ham, the notice of intent to destroy evidence, generally that's signed by the parties as well. Y'all just mark through it as.
That's because that's on the motion, Judge. That was originally signed, so that document would
Yeah, that's already been
that would be fine.
Placed on probation.
I don't think we need to duplicate it.
And then the agreement on this new indictment, the state jail felony, again, this
DUI.
is unagreed, right?
Correct.
And it's, what are we doing? Whatever the court does, are y'all waiving right of appeal or anything like that?
Yes, Your Honor. That's why it's we've got a signed deal that whatever you decide, we'll agree to run it concurrent. So if you do probation, we'll agree that those terms run concurrent. If you do prison and state jail time, we'll agree that that time runs concurrent. It's all a part of him accepting the responsibility today.
I don't think his accepting responsibility was very convincing for me.
Bill Alvis.
Perhaps if we had the clause that he always has to wear that suit. Yeah, bow tie's a little crooked. I just don't think a flashy suit was the right choice to walk into court. I mean, yes, wear a suit, wear a bow tie, that's great, but be conservative, be conformative, would probably carry a better message than stand out flashy.
Nothing further to add. Let's take these up in numerical sequence. We have 23 CR 168.
Now he's nervous.
The motion to revoke probation in the defendant's case, and the court is going to make the following findings after listening to the evidence presented and the arguments of counsel. That, again, the defendant was placed on regular probation as he entered his guilty plea for the third-degree felony of evading arrest or detention with a motor vehicle on January 28th, 2025. He was mentally competent to enter his guilty plea at that time. there was sufficient evidence supporting his guilty plea to find him guilty beyond a reasonable doubt. And the court found the defendant guilty beyond a reasonable doubt based upon the plea agreement that was reached. The defendant was sentenced to 10 years in prison, and that was suspended. He was placed on regular probation for 10 years. In today's hearing, the defendant admitted violating the terms of conditions of probation by committing the offense of operating a motor vehicle while intoxicated with a child passenger under 15 years of age on or about August 30th, 2025, which would have been 7 or 8 months into his probation. And also, he pleaded true to being at a location other than his residence at approximately 1:08 a.m. on or about August 30th, 2025. Each of these allegations, 1 and 2, are violations of his probation order, as he was required to abstain from committing any offense against the laws of the state or any other state or the United States. And also, he was required to be inside his home every day between 10 p.m. and 6 a.m. The court finds that there is sufficient evidence supporting this motion to grant it by a preponderance of the evidence or greater. The defendant pleaded true to these allegations voluntarily, knowingly, intelligently. That is enough to grant this motion by a preponderance of the evidence or greater. It is so granted. Your probation is hereby revoked, and you are facing no less than 2 nor more than 10 years confinement in prison. And from the evidence presented, the court finds that it is in the best interests of justice to assess your punishment at confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. You have served about half a year. You will be given credit for all that time you have served. This sentence shall run concurrently with what is about to happen here in this 26 CR 156.
It's a year and a half for the
In this case, the court finds that the defendant under this case, you were charged with this indictment on or about August 30th, 2025, committing the state jail felony of operating a motor vehicle while intoxicated with a child passenger. And you are pleading guilty to that, sir, today, correct?
Yes, sir.
You were doing this voluntarily, knowingly, intelligently, based upon discussions with your attorney. And there is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. As State's Exhibit 1, which is admitted into this hearing, states that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty.
This could be a longer sentence.
And you are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. In this case, you are facing no less than 180 days up to 2 years in the state jail. I find the evidence submitted sufficient to find you guilty beyond a reasonable doubt. I hereby find you guilty beyond a reasonable doubt of this offense. You are hereby sentenced to confinement in the state jail for a term of 2 years.
Okay, so we got 2 years.
And
2 years from today.
Listen closely. That's going to be suspended. You will be placed on regular probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Most importantly, we're going to focus on some of the issues that we've addressed that you have kind of fought with in your composure, and we will help you. We want you to get across the finish line. These sentences are going to run concurrently with each other, by the way. So what happens is you have a few months, maybe, or less, to complete the service of this sentence of 2 years that the court has assessed on this case that you were on probation for. And again, we can't take lightly the major reason that you are revoked is because you had, my God, a child in the car. And it is a felony to operate a motor vehicle with a child passenger. We can't ignore that. It has its consequences. It's a felony. You got 2 felony convictions. You've had 2 felony convictions even before today.
Now 3 felonies.
You got to be careful. Those 2 felony convictions,
16 misdemeanors.
A third felony above a state jail felony, you're looking at 25 to life. So for yourself and for the betterment and well-being of your family that you profess that you love, which I think you do, you put the child in harm's way, and that you have to be held accountable for. And these are all issues that are fixable. Plus, you are surrounding yourself with people who are role models and great examples. Failure is not an option for you, especially with your surrounding with all this support. The court finds that under these circumstances, that a 2-year sentence in this case, which is the lowest that can be given, is appropriate under the circumstances and under the changes that you have made in your personal life in commitment toward responsible behavior. But once again, it's a felony offense that you committed, and a child was in harm's way, plus others, and that has to have its own accountability. Okay, the court finds that this
he wants the lawyer to say something.
These 2 sets of judgments are in the best interest of justice and are fair based upon what this court has heard and the evidence presented. And in this other case, this one, the second one that was unagreed, you have a right to appeal that. It wasn't an agreed decision unless you waive rights of appeal, and we will talk about that. There will be on the conditions of probation on Mr. Jobert's case here, on this second case that we're putting him on probation for, state jail felony. Make sure we target the issues that were addressed today on drinking and the moral reclamation therapy is a great program which helps defendants understand and appreciate decisions that they're about to make and the consequences, and it really helps folks change their method of reacting too quickly and making mistakes versus composing yourself when a decision has to be made, especially under stress, and methodically thinking through the decision for the right choice. And the moral reclamation therapy, MRT we call it, really works great for people, and it's a program that you can use the rest of your life to be a better person. Anything else?
Can I ask one question?
It's a rental? This suit? Can I just take it off here? And I'll just go to jail in my skivvies?
Yeah.
Yeah.
You had a hold.
Yes, I had a hold when I left the town.
My client is saying that while he was in the penitentiary on that 4 years.
No, after the 4 years, and I got out on parole. Parole was broke. My parole.
Now you were on parole.
Yeah, they revoked it because it was indecent exposure, but they had to induce the exposure in a better detention.
You have to be in the penitentiary and have a detention.
Yeah, hold on, they can't pick me up for a better detention.
While you were after they revoked your parole. Okay. Yeah. So what he's saying is that there's additional credit.
I don't know what it is, but
I'll get with the clerk here.
But
yeah, we'll get this.
Coordinator works with TDC on that, and they will make a determination of of how much it is. And if there's a challenge to it, let me know. But
yes,
I've been doing this 19 and a half years, and all challenges have been proven wrong.
Yes.
In 19, they're pretty good at what they do on determining how much credit. But I don't know what they're going to do on this new case, because you're creditable in a quarter of your time, and he served almost half. So
we'll check with
it
TDC.
may be one of those where he goes in and out.
We'll check with TDC, make sure he gets proper credit.
Anything
go
else to
in
add
and
on
out.
this?
Okay.
Do you hear that? He could go in and out.
All right.
They could book
right
him.
Now, he's going to be taken into custody for the sentence. Do you need to take care of any private things with
your suit?
Making sure that folks get what you're. No findings.
Or she's going to check TDC.
Terms and conditions which are normal and customary for DWI cases.
He could get in and out the same day, says the judge. Which means he might be able to get booked into prison, get released.
We're assessed on this, Langston. What do you have? Great.
Okay, hang on. We've got somewhere else to go. He can get booked and released the same day and return his tux before it's late. That's something else. We're going to join a little court we haven't been in a long time. It's the ice fishing court, just to see what's going on. I'm not sure what it is, but I think it's traffic related, but it's also like civil. We're joining right as they are picking up the Pledge of Allegiance. So if you all just stand and continue with me with that would be great. Here we go. Right there. To the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be seated. Good morning.
And he shuts it down promptly. It's okay. That's all we needed.
Welcome to the circuit court for Friday, August 7th. Here. My document's not here. Excuse me one moment, but before we go, we'll try to get through all the cases this morning as efficiently as possible. Understand some cases may take a little bit more than others time-wise, so we try to.
Let's go to the channel. So that's all we got. Now let's jump straight to the case.
Jennifer Turner versus Lindsay Ritter, file number 268254PH.
You guys remember the ice fishing court, right?
Terminate a personal protection order. The moving party is Ritter's in the courtroom. Ms. Turner is also in the courtroom. Would you both please raise your right hands?
A PPO termination.
The testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Thank you. The court on June 25th.
Fun fact, the judge controls the camera in this one.
Personal protection order filed by the petitioner, Ms. Turner against Mr. Ritter. And again, that was June 25, 2026. Set to expire January 25, 2027. After the order was entered, Ms. Ritter timely filed a motion to terminate the personal protection order. And so we'll proceed in that fashion, but the understanding is, under the law, it's the petitioner's burden to establish that a personal protection order should continue. And so we'll proceed in that fashion. Also, as I understand it, there was a USB that was submitted. And the court did review that as well.
Video.
Apparently it was some sort of video from inside a motor vehicle, which the court reviewed. So, Ms. Turner, why do you believe that the personal protection order should continue?
Because of that USB drive. I mean, I had an active PPO when that was presented to me, and she was following me around with bad acts.
And so this is in part a motion to find her in contempt for violation of the personal protection order?
Guess so, yeah.
You didn't file that, correct?
What do you mean?
You didn't file a motion to have her jailed. No, you did. Here it is.
I did. I took the USB drive to the Bad Axe City PD, and they told me I had to take it up to the clerk's office. When I brought it up to the clerk's office, they told me PD should handle it. But then the clerk's office helped me. They gave me the paperwork to fill out and told me what to do with it.
So the video that's on the USB drive, whose vehicle is that in?
That is out of Miss Ritter's vehicle.
Okay. Okay. You reviewed that as well?
Yes.
So you believe that's a violation of the personal protection order? Why?
Because she was intentionally following me.
Okay. And what do you base that upon?
That she was following me. She was behind my vehicle and then going around corners to, I don't know. I didn't even know she was there until I saw that video. So.
Okay. So on the date in question that the video was made, you were going southbound on Southport Crescent, correct? Is that correct?
Yes, that is correct.
Okay. Where were you going to?
I was going from my work. I work at Independent Bank. I was off for the day, but I stopped there to see my manager. Her husband, they own Thumb Auto Glass, or Thumb Glass.
She's ready to get her own auto parts.
Yep, correct.
And you were to go there?
Yep, I was going there because my windshield was cracked. I was going to pull up there. I drove through the light. I was going to pull up there, but there was another truck backing out. It was kind of raining. There were other cars parked on the side of the road. I've never been there before, so I was trying to find a driveway, and I just decided to drive around the block to wait for that guy to leave so then I could pull in. So that's what I was doing that day.
So you drove past the driveway.
Mm-hmm.
You turned on what street? Would it be the first street?
I'm not familiar with Bad Axe. Yes, I just drove the block and turned left.
Okay, there's a doctor's office, used to be a church on the
I think so, yeah.
You turned left there?
Yep, and then just drove down and turned left and came back around.
I believe the video then shows you what I call the street that's on where the park is.
The park is, yep.
And you drove through that intersection.
Yep. Just up to the main road to go back to the light.
What color is the vehicle?
My vehicle is yellow.
Yellow.
It was
And
all yellow.
Then there's a third video where you're at the main traffic light where you were facing west.
Correct, because I was in the left turn lane.
And you were going back then to?
Yes, and then I pulled into Thumb Glass.
And your position is that the respondent was at the same intersection facing north.
She was, but all the videos show her
We watched that first this
going
morning.
around to find my car.
Okay. Okay. And beside that issue, why do you believe the personal protection order should continue?
At the time when I submitted this, she was pretty aggressively following me around, driving around my house, beeping the horn, getting behind me at lunch, beeping the horn, flipping me off. I mean, when I came to submit this paperwork to the clerk's office the first time, she followed me here, and I have witnesses. I called dispatch to let them know that she was following me. But calling 911 isn't the most convenient thing, and by the time I got someone on the phone, I was literally walking out the courthouse steps.
It's not convenient.
Do you know of any reason why this alleged behavior is going on?
I've never met her before in my life, but as I stated, apparently she dated one of my exes for a short time and was keeping tabs on me for quite a while.
One of those.
So you don't know her from Eve in any other situation?
Or Adam.
And how many times has this alleged following behavior been occurring?
It was several times. I know I noted everything in my initial statement, and then after that, there was a handful of times I caught her behind me, but I couldn't get my camera up in time. But
Ms. Ritter, your response.
Is it okay if I just read my opening?
Sure, absolutely.
Your Honor, my name is Lindsay Ritter, and I'm the respondent in this matter. On Friday, June 19th, my former boyfriend, Kevin Brown, broke up with me. That morning on June 20th, early in the morning, I found his truck parked outside of a home that belonged to Jennifer Turner, his ex-girlfriend. I contacted both of them that morning trying to talk things out. Clearly I was upset. I just got cheated on. Jennifer Turner never responded to my text, nor did she answer my calls. She never sent me a text asking me not to contact her. We never had a conversation. I blocked her number the next day and I thought things subsided. Almost a week later, I got served with a personal protection order against Miss Jennifer Turner. I was absolutely appalled and in disgust with some of the statements that I was reading and knew that I wasn't going to let this woman try to take my rights away from me over hearsay and false allegations because she is upset that I found out about a situation I wasn't supposed to. The evidence that I bring forward today will show that the petitioner's statements are factually incorrect and fail to meet the legal standard for a personal protection order. Ms. Jennifer Turner has not met the required burden of proof, and the claims presented in her request lack the specific factual support needed to sustain a personal protection order. Today, I will present time cards, photo evidence from security cameras, dash cam footage from my vehicle, and a witness testimony that will contradict the petitioner's allegations. The petitioner wants you to believe I have committed a crime, but the evidence presented today will tell a different story. This case is not about assumptions or hearsay, it is about facts. Facts that will prove that there was no threat, stalking behavior, or harassment, and that this order should be dismissed.
All right. Do you have any other witnesses you wish to call?
Yeah, Kevin Brown.
Mr. Brown, would you please step up to the witness stand?
So was it over or was it not over? That's my question.
You solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir. Sir, would you please state your name?
My name is Kevin Brown.
Yes, go ahead. You have some questions, please step up to the podium and you may ask some questions.
Did you witness Ms. Ritter stalking me?
Yes.
And how so?
When we came to the courthouse here to file for PTOs at the same time, not just for yourself, but for myself and for my daughter as well. As I got here before you did, you came from the main lane in town, coming through this way, pulled into your parking spot on the right-hand side of the road. Ms. Ritter was behind you. You had already sent me a message that she was behind you at the main light. She came behind you and was honking repeatedly as she went by. We came in, found out the paperwork that we found online was not the correct paperwork, so we were in there 20 minutes, 25 minutes at the county clerk's building here, so we could start filling out forms. Upon leaving, Ms. Ritter was driving past us heading west. Circled around the main light, came back up at the first block and stopped there. We have pictures of her stopped there at the light. She gave us a look, threw her arms up in the air and sped off and took off like that. So I can say 100% that was undoubtedly her. I'm happy with the situation. I know you have shown me videos that you have taken sitting on your porch of Miss Ritter driving by your house, turning around in the neighbor's driveway next door, so that as she had seen you sitting on the porch waiting to video her and do that. That first night, Miss Ritter mentioned that she did contact us early in the morning. That was 1:30, 2 o'clock in the morning, something along those lines. I don't know how she got Miss Turner's phone number. It's not anything that I've been able to look up at any point in time. It's an unlisted phone number, but yes, she somehow had it all ready to call her at middle of the night after midnight. You sent me several pictures of her behind you. You've texted me several times that she's been behind you, is circling your work. Yes, Miss Ritter does live 2 blocks away from the bank where Miss Turner works, but there's no need to be circling the bank to get to her apartment complex.
Any other questions?
Did I know her while you were dating her? Had we had any communication before you told me that she was doing all of this?
No.
I don't think I have any more questions. So.
Ms. Ritter?
For
For questions, yes.
So you're saying that you did see me drive past the courthouse, correct? The day that you and
Several
Mr.
times, yes.
Okay, did you ever get a subpoena to request this information, or do you have any of the video footage from me?
We have the pictures that were submitted to the court for the PPOs of you sitting outside.
I've never received.
I guess not those ones, because this was the day that we were submitting.
Wait. No, I don't need to hear from petitioner. This is respondent. Go ahead, Ms. Ritter, go ahead.
So
The
you
court might
don't
have received those because my PPO was not submitted until the next week. So I don't know.
I do not have any videos of my, or video footage or photo evidence in any of these personal protection orders of me in front of a courthouse or my vehicle driving past a courthouse. So did you request a subpoena from the courts to get that? They do have cameras outside of the courthouse, correct?
I don't know what cameras they have. I assume they have cameras.
So did you request a subpoena to get the video footage of me driving by the courthouse that day?
No, because she had already submitted her paperwork that day.
But you are aware you can still file more paperwork after it's the first.
I'm not familiar with any of this because I don't come to court.
Okay. So you do have these photos of me outside of the courthouse?
Correct.
And you are sure it's my vehicle with my license plate?
Correct.
And it shows in those photos that
these are bad questions.
My license plate clearly and me in that
No, it
vehicle?
does not show your license plate. It's the front of your vehicle.
So how are you sure that it's me in that?
I witnessed you in the driver's seat.
That's all I have for questions.
You just proved their case.
Okay, let's see if I can put this together. How do you know Ms. Ritter?
We dated for a period of time.
Okay. And obviously the dating relationship ended. When did it end?
She was at work. I sent her a message. I had dropped off all of her belongings to her apartment.
I'm just asking when.
No, keep going.
Would have been June. I look up the date. It was Father's Day weekend.
That's June 9th.
Father's Day
She
weekend.
remembers.
Correct. Yes, sir.
Okay. Do you have a relationship with the petitioner?
Yes.
Is it a dating relationship?
Yes, sir.
Okay.
When did it start?
And prior to your allegations that there was some following going on at the courthouse when you filed the personal protection order, do you have any firsthand knowledge of alleged stalking or repeated contact with the petitioner by the respondent before the court date, before you appeared at the courthouse?
To file for the PPO?
Yes.
Yes, so Ms. Turner and I were in contact, and she had sent me several different videos of Ms. Ritter driving by her house, stopping and honking. We have a video, I believe all of these were turned into the Hufford Police Department.
Okay.
And so.
But you don't have firsthand knowledge.
I have one firsthand occurrence when that night she came over outside, was honking in the middle of the night, sent me videos directly on Snapchat of her standing outside my vehicle outside.
Who sent videos?
Miss Ritter sent me videos
Of what?
of herself on the road, behind my vehicle, around my vehicle, that was parked on the road next to Miss Turner's house.
Okay.
So she sent me those where she was frustrated. She went back to Bad X, contacted Bad X Police Department, filed a report, and the officer told her no contact either way, told me no contact either way. I continued to get contact. Miss Turner, we were still sitting at her house, and several more times throughout the night, a car that we did not see drove by honking repeatedly the exact same manner that Miss Ritter did when she was outside Ms. Turner's house.
But you have no visual to indicate for sure that it was.
No, not that it was for sure, but the first occurrence obviously was because she sent me a video of her being there as she was sitting outside honking the horn.
Okay. Any questions in light of the courts? Yes. Any questions in light of the court's questions?
Yes. You said in this last video, I videoed myself honking the horn past Miss Turner's house. That's in the video that I sent you?
No, you sent me the video of you outside my vehicle, outside Ms. Turner's house. But at that time, you were honking repeatedly several times before the video and after the video. Who else would be doing that at 2 o'clock in the morning?
So you've never seen me honking my horn,
You look out
or
the window and could see you doing it.
you never seen me honking my horn or seen me driving past her house at all that night?
Not those extra times that you did later.
So the first time that you were claiming that I drove past her house, you did see me outside in my vehicle?
You sent me a Snapchat video of yourself being at that premises.
I was in the video myself.
You were talking in the video. You were holding your phone, talking in the video.
So you didn't see me driving past Ms. Turner's house at all? You don't have that? You didn't record that at all?
No.
If there was a vehicle outside, neither of you guys recorded a vehicle driving past honking, blaring their horn?
No.
Did you call the police and report it afterwards?
Yes.
What police department did you call?
Ugly Police Department.
And did they come and did you write a report?
They did not come.
Why did they not come?
That's a question for them.
So you called the police and they didn't come to let you write a report?
That's a question for them. They're not regularly scheduled.
Did either of you guys get a subpoena to have that officer come in here to state that you got a phone call?
It's the standard work line.
Can you answer the question?
I don't file for subpoenas. I don't know how the court process works like you do.
How are you thinking that I know how the court process works?
You know obviously more how it works than I do.
The
fact that you can ask me these
was
questions.
this not up to you to make sure that you were ready for court, you and Ms. Turner, to make sure that you had all your facts ready?
I am not required to be here today.
Why are you here then?
To make sure that everything gets on record as it should be.
That's all the questions I have.
You may step down.
Thank you, sir.
It's not over between them.
There was a police report filed with Ubley, and there was a case number. I included that in my PPO paperwork.
I didn't see that.
Okay.
I didn't see that. All right. Do we should call witnesses?
Yes.
Go ahead.
This would be for the violation of the PPO though that Ms. Turner is.
Okay.
Okay, so my witness is Miss Regine Allen. She's the manager of the Sunoco gas station in Bad Axe.
Would you please step up to the witness stand?
Do you want me to explain why? Okay.
Please raise your hand.
Do you solemnly swear or affirm the testimony you're about to give in this case, the truth, the whole truth, nothing but the truth, so help you God? Yes.
Miss, would you please state your name for the record?
Regine Allen, I can spell that for you.
Please.
REAGINE.
She's advertising pizza.
ALLEN.
$4.99. Get your pizza. $4.99. I know where we're going for lunch.
On June 30th at approximately 12:07 p.m., you were working at the gas station that you worked at, correct? Yes. And at 12:07 p.m., you said you were outside that day, right? You had somebody training inside. You were outside doing something outside at 12:07 p.m.
No, I was getting a job interview in my office. My boss was present, and I had an employee at the front end of the store.
Okay. And did anyone in your store hear any honking or any noise outside at 12:07 p.m.?
No.
I came to you with a subpoena, and we went and looked at the camera footage facing the road from 12:05 to 12:10 p.m. on June 30th, correct?
Yes.
Did we ever see a yellow Bronco driving east or west from 12:05 to 12:10 on that day? No. And then is it true we could not get the video footage to save on a flash drive to turn into the court, so we had to have you come in today to testify?
Yes, I could not figure out a single way to get the video saved onto a flash drive at all. I'm very new at my job, and my boss was not available to help provide me with the information to get the video saved.
That's all the questions I have for
Questions?
No, thank you.
You're employed where again?
Sunoco gas station, the express stop across from Franklin and West here.
Do you have a sale on pizza?
Yes.
Okay. All right, I don't have any questions. Any objections? Would this be an excuse? Any objection? Your excuse as well.
Thank you. You guys have a good day.
You too. Further proofs?
So in this violation order that Ms. Turner turned in, it states that the PPO was signed and dated on June 25th and on June 30th at approximately 12:07 p.m. She was on her lunch break. She was driving down 142 just before self-serve lumber. It says, and she heard somebody blowing their horn. She looked up to see me, apparently in her rear view mirror, swerving, blowing my horn, flipping her off, and then I quickly turned down a side road. This would not be possible if she wasn't even on that road between 12:05 to 12:10, driving east or west. So this is not a factual statement that she put in here for a violation.
Okay. Any response to that?
I don't know exactly what street she drove down. I'm not familiar with all the side streets in Bad Axe. I don't live here, but it was her. It might have been before the Sunoco, but I'm not going to subpoena a bunch of businesses and upkeep.
Is the town called Bad
Isn't the alleged
Axe?
violation
It's really for the drive that I sent
USB
in.
drive
Yes,
here, right here, this part of town?
that's correct.
There's two different ones in here that.
Yes.
Okay. All right. What do you wish regarding the personal protection order?
That it stay in place.
Okay. Your wish.
Your Honor, this case is not about protection. It is about misuse of the legal system. The petitioner has made serious claims, but claims alone are not true. Over the course of this hearing, I've shown clear inconsistencies in their testimony, a lack of credible evidence, and motives that point toward personal gain rather than genuine fear. I respectfully ask the court to deny this petition, recognizing that the evidence, or rather the lack of it, speaks louder than any accusation.
Very well. Petitioner has a burden of persuasion to establish a motion to either terminate or modify a PPO. It's under the Pickles case. Also, burden of proof rests upon the petitioner if there's a violation. And the burden continues that way. And the court has considered the testimony, considered all the evidence. Clearly, a personal protection order was authorized. And after hearing the proofs on a motion to terminate, the court finds that there is insufficient evidence to terminate the personal protection order. Clearly, there was a reason for it to begin with. And from the testimony of Mr. Brown as well, there was even allegations regarding behaviors the date the personal protection order was sought. So clearly, there's a sufficient basis to continue the PPO. Relative to the alleged violations, one of which was alleged to have occurred at the Mr. Chips, I call it Mr. Chips, the Sunoco, on the east end of town in Bad Axe. There was testimony from Ms. Allen indicating that there was no video of the petitioner's vehicle in that area. However, court does take judicial notice that I don't know what camera angle it is, but clearly self-serve lumber is to the west of the Shell station. I guess it's Shell. Sunoco, the Sunoco gas station. So it's alleged that apparently there was beeping of the horn and all of that going on. I find insufficient proof to find a violation there. The second part, though, is there were 3 videos submitted to the court on the USB drive. It appears to be either a dash cam or maybe a phone being held by someone in the vehicle. Illegal. Where you see the petitioner's vehicle go by. actually going down Southport Crescent. Suppose, according to her testimony, she used to go to get glass repaired at Thumb Glass. There was a vehicle backing out, so she couldn't turn into the driveway. She turns left at the block where the Dr. Roston's office is, takes that to the end, to the dead end, which I would call Park Street, but that's really not Park Street. That's, I believe, South Hanselman. Takes South Hanselman north. The respondent, who apparently ran the video, was at the corner of Hanselman and West South Street. So it appears that, according to the video, petitioner's vehicle is in front, respondent is behind, petitioner goes past the Thumb Glass, turns left, respondent turns left at South Hanselman. They meet again at the intersection because you see the vehicle go by, petitioner's vehicle go by. And then there's a third video where, again, the petitioner is at the main light, and then so is the respondent. So there was a valid personal protection order at the time. And clearly, I don't know how you can chance contact each other that many times. I find a violation of the personal protection. Now, you've had your opportunity. I find a violation of the personal protection order. And it appears that this is a relationship between Mr. Brown and Ms. Ritter that turned. On the bad side, there's a bad breakup. There's now someone else in the picture, and the behaviors that are being alleged, the court finds, have been established by the proper standard. Regarding a sanction in this matter, and the court has done this before, this is not a situation where someone was physically harmed, physically threatened. However, I can understand why someone would feel apprehensive, and regarding alleged harassment, which I clearly understand. And so as a result for the sanction, it's simply this, Ms. Ritter. If you see the petitioner, if she is driving down the road in her car, don't follow her. Don't.
I went the other way in that video.
Don't associate with her. But there were 3 encounters.
I went the opposite way each time.
I understand.
And went to the sheriff's department
Again,
after.
you've had the opportunity to speak.
Yes, sir.
I found a violation of the personal protection order. I'm not going to issue a sanction. But what I'm telling you is, drop this relationship.
Absolutely. I already have.
He is clearly in a different relationship. Look elsewhere. On the same side, I don't want any fueling of the fire here by anyone. Just mind what the personal protection order calls for. Stay away from each other, and we'll leave it at that. That's all. I wish you all the best. Personal protection order remains. No other sanctions will be imposed. You're free to go.
Thank you.
You two go first.
You're free to go separately because you need it. Guess what's happening up in Thurston, Washington? I know we've been jumping through a lot of courts and we haven't taken a lunch yet, but Thurston, Washington has started their their civil calendar, which always delivers. And so we're going to pop up there. This might be the last one for the day. I don't know. We'll see. We'll see what happens here. Morning, Your Honor.
Previously reviewed the file submitted in this case, and I understand that this is a request by Ms. Jarvis to seek return on $3,547 of
we're 1.25 speed because
money that she paid back to the
talks so
HOA for
slow.
Harbor House based on the HOA's request that she believed had originally been approved by the HOA under the prior president of the HOA. Okay. Is that an accurate summation generally of the issue before the court?
It's HOA
Yes, it is.
issue.
Okay.
Well, he was an unpaid.
Go ahead, Ms. Adams.
He was an unpaid manager.
Okay. But he was the president of the HOA at the time, or whatever it's called.
No, he was the manager. Why is it?
Why is it?
It's backfeeding.
It's echoing.
Did I do something wrong?
No, you're coming through appropriately here.
Oh, okay.
Be
I don't know what
appropriate
it was. Anyway, he was the unpaid manager and he was very ill at the time.
Right. He passed away shortly after this happened, I think.
Yes.
Sad. It's been a fun day of court hopping. Had some good ones. We have an HOA issue. Take it to court. We're on 1.25 speed because they're also long pauses. We could watch entire traffic tickets from Royal Oak. I'm sorry, I got corrected during these pauses. Hang on. We just skipped 30 seconds and he's still reading. What do we have down there? Who's that? Oh, that's Judge. Oh, this landlord tenant. Never mind. I was going to say Judge Middleton's doing stuff, but it's LTT stuff. Take your time, Your Honor, but some of us have to have lunch before it's cold.
I'll give you the page number.
Let's go back. There we go.
Last week, and I thought I.
Okay. Here we go. He's almost done. Thanks for. She appreciates that red pen.
What I'm looking for, and as I said, I reviewed these last week, and I thought I remembered seeing something, an email or something, Ms. Jarvis, from Mr. Riley. Is there one in your exhibit, or is it your memory of the conversations you had with him? I can't recall now.
Yes, there is an email here that talks about setting up a meeting to discuss the electrical issues as well as some other things. I'll give you the page number. Let's see. It should be on page 51. So it was an email starting on August 5th, and then we met on, I believe, August 11th, or sorry, Monday, the following Monday.
All right. So what I see on page 51 is a response from Mr. Riley, who says Monday at 11 works for me. And you had your initial email had made a request concerning some of the issues set forth under your topics heading. Is there anything else in Mr. Riley's, any other written documentation of Mr. Riley's position on this? Do you have any confirmation emails or anything saying, yes, I'm agreeing that the HOA should pay for the electrical upgrades to the storage unit or shed? Is there anything?
Okay, his approval is demonstrated by the fact that he paid. And when Woods Electric did the work, he asked for the Woods Electric bill to be sent to him. They made a mistake and sent it to me. And I believe there's something in this packet that shows, let me get to a page here, shows him asking for, or them asking for the new address. Okay, so that would be page 58. Again, Jerry is saying, please have them send the address to me, send the invoice to me, and it was mistakenly sent to me and had to be resent to him. That was his request because he fully intended to pay for it.
Okay.
Can I comment on that?
Yep, yeah. I'm gonna get to you, Ms. Adams,
Okay.
first. I'm just trying to get the basis of the plaintiff's case first.
Just take your time, Judge. It's just a whole room full of people waiting.
Right, so, Mr. Jarvis, what I see on 58 is an email from you to, I'm assuming, Woods Electric, saying, please send it to a different address.
Okay, so on 58, the email is basically, the name Ken is the estimator from Woods Electric. And I just wanted to let him know that Ken's going to be sending him the invoice, but I just needed to be reminded what his address was. I didn't know it.
Okay. So technically, I mean, the email is from you. It's not Mr. Riley's words, but your argument's going to be, I wouldn't have sent that if Mr. Riley hadn't told me to make sure it got sent to him.
Exactly right. Exactly right. And yeah.
All right. And Ms. Adams, you are currently the condo manager, is that right?
Yes, I'm the unpaid manager.
Right. So
how do you
give me
feel
some
about
idea, since you are serving in that capacity, what do you believe to be the authority of the condo or HOA manager?
Oh, there's nothing really other than they make the decision. The condo association makes the decisions and I execute them. That's pretty much it.
So how you get rid of tenants?
Okay. So
what decisions are these again?
In this case, it appears to be
Who has
an
to go?
upgrade, probably by the installation of an electrical panel into a storage or into a shed. I'll just call it a shed because I'm not sure what it's used for. But I think I read in some of the defense exhibits that that's you view it as personally associated with Ms. Jarvis's condo because she has a lock on it and it's right outside of her unit. And it's not a common facility, and Ms. Jarvis has been arguing that it's a common facility that should be supported by the assessments of the HOA.
Can I clarify that for you?
Yeah, please do.
Okay,
there's a lot of documents in here, so that's why I'm asking questions.
Yeah, it becomes confusing, and I think that's one of the things that Jerry got confused on as well. There is, under her bedroom, there is a storage area, and that has been considered by the current owners of the property here as a common area, and I can give you a whole bunch of reasons. But anyway, the thing is that there's also the shed, and the shed is Unit 3's personal property, and it's actually on her title. The common storage area is not on her title. It's actually listed in the square footage on the declaration for the association for common areas. But she did receive something that showed that on a different listing, a different filing with a different number, it shows that it's her unit. So it has become confusing just in the last few days because we both didn't know that there's a difference there. Okay, so let's go back to your others.
Well, okay, let's just stop right there because I want to make sure I understand this.
And
the dispute is not about the basement storage area. The dispute is about the shed. Is that correct?
Yes, although she started that there saying that there was electrical problems there. I have read through all of the inspector's report, the home inspector that she had, and the electrician bids that she got. I do not see anything except that she wanted to upgrade the look. It had just been a light with a string, and it now has a switch, with a button to push to have it come on, and also a socket next to it. That's it in the storage
That's the
area.
violation?
In the shed, it had to have a fuse box replaced. It had to have it rewired through the whole thing, and it had to be wired from the shed to the main building. So therefore, that's and we didn't get asked as to whether we wanted to have it upgraded in the storage area at all. So therefore, that's where the problem is.
Okay, so the $3,547 paid for both, paid for one. Tell me.
Okay, it paid for everything except we did not charge her for the tree light replacement that the
Right, I saw that.
electrician. Yeah, we are paying for the electricity on that, and that's fine. We just don't want to pay for the electricity in her private shed.
Okay, so, but you said some work was done in the downstairs storage unit, and
Correct.
then other work was done on the shed. And so the $3,547 that Ms. Jarvis has paid back at your request to Harbor House, was that money just for the shed, or was that money also for the storage unit downstairs?
It was for both.
Okay, and do you know, can you break out costs? What cost goes to the shed and what cost goes to the storage unit?
I don't think we can from the it being D of mine, because we've got Woods's electrical on there. I don't think we can. I don't think there's a way to do it. Sorry, Nathan.
Okay.
Yeah, I don't have enough detail to do that. No.
Okay.
And she required it. We didn't. If we had been asked, we would not have paid for it. It was sufficient as it was, and none of the home inspector nor the
grade to what is deemed a common area. Is that correct?
Yes, it had been for 20 years, but Miss Jarvis thinks it's her private area.
Okay. No, I'm not talking about the shed. I'm talking about the storage unit.
No, she said it. The storage unit is hers. That's why she put in the lock between my apartment and that common area, that storage area.
Okay. So is there a lock on both the shed and the storage area?
No, no, there's none on the storage area to get into it from the street. But between my private patio and that common area, there is now a lock.
I don't know how it got there. I didn't put it there.
Okay. All right. So is there a dispute so I understand that I'm hearing that there's a basement storage unit, and do you both agree it's common area? Or Ms. Jarvis, what do you think of the basement storage unit? Is that yours or is it common?
Your Honor, I submitted some maps that I was given when I purchased the property, and included in condo 3 is the basement storage area, the shed, and then another open area. That is indicated on the maps. That's on page 8, and it's recorded. That's what the assessor says is part of unit number 3. I have exclusive use of the basement storage, the shed, and an open area that is between the two. And all of this electrical work is interconnected. It's not standalone. One doesn't work without the other. The shed doesn't work unless the basement is fixed. The tree light doesn't work unless the shed is fixed. So it was an upgrade, repair, bringing everything to code, taking care of safety issues that were a fire risk. That's in the report by the inspector. It was done under the guidance of the HOA manager, his tutelage as far as what the process was. I, as a new condo owner, didn't make this stuff up. So what did the process of finding an electrician, working with the HOA manager to figure out what was the best approach. He added some things to the original plan based on things he thought the other owners would really appreciate. And I project managed it to the completion where he was given the invoice and he paid it almost a year ago.
Okay, so let me say you indicate the maps you saw that you relied on and you believe the assessor is rating your unit on tax liabilities for as to include both the basement storage and the shed.
Correct.
So that would, I think, strengthen Ms. Adams' argument that the work was done privately for you and should not have been paid for by the HOA. So what's your thought on that?
Well, my thought is that I don't own or control the wiring inside the walls or ceilings of my property, which is identified as Unit 3. That, whether a condo owner can be held responsible for repairs of the electrical system in the condo building is really the question here. And RCW 6434-204 states that the condo owner only owns and controls the interior of their unit, essentially from the paint in. So I have exclusive use of these spaces, but I don't own the building. I don't own the structure. I don't own the conduit, the wiring, the walls. I just have exclusive use, like I have exclusive use of this condo from the paint in. And that's what I'm going on is the level of responsibility is from the paint in and the floor up. But the structure of the building, based on what I've seen in the CCNRs and the Washington statutes, is that, things like wiring and conduit, roofs and antennas all belong to the HOA for the condo building.
Right. But just hypothetically, I mean, if a unit owner decided to put, I don't know, dance lights in their condo, which required special wiring, is the HOA then obligated to do that?
That's a pretty radical example. I don't think so.
It is, yeah. This is how lawyers work. We're looking at what the argument it is and seeing how, if it stretches credulity, then we have a problem with it. So, I had read what you said and quoted the statute, which said that the electrical circuits are the common obligation. That makes sense, of course. But if they serve only one purpose, then that diminishes the ability of the electrical circuit to be a common obligation as opposed to the obligation of the unit owner. So tell me your theory on that.
I guess my theory is that when you talk about safety, so when my inspector flagged that there was a serious safety issue with the wiring, which was on the back of Carolyn's condo and underneath mine, that's when I went to the HOA manager and said, this is an insurance issue. I mean, it is something that is too high a priority to let go. I know Carolyn thinks I asked for the electrical work to be done cosmetically because there was just a string on a light. But bottom line is, this gentleman who was our HOA manager for 18 years agreed it was too important to take care of on behalf of everybody. And it's not optional. The safety is not optional, and it impacts all of us, not just me. Okay, so the dance lights are optional. In any case, I think that, as a condo owner working with the HOA manager at the time, I think I did the right thing on behalf of my space and all the other unit owners. I don't know why this electrical had been such a disaster and people hadn't taken care of it before. But as a new owner, I want to make sure that the place was safe and that I followed the rules to get it taken care of as quickly as possible so we could all not worry about it. And it's an electrical upgrade, repair, bringing things to code, making things safe, that it's all interconnected. And yes, I use the space as I share that space. To be honest with you, I share that space with the other condo owners, even though it's exclusively my space. The shed I don't share. Why? Because I've had vandalism against my mailbox. And I don't trust that I can leave my shed open because I have a wine collection in there. So for that reason, I lock one of my personal spaces and I share the other space with Carolyn and the other owners. But again, I think it's really important for everybody to acknowledge that for all these pieces to work, it wasn't a one-shot repair. Everything had to be fixed together. They're all interconnected.
Okay. And Ms. Adams,
what if you installed a floor-to-ceiling vertical handrail?
An expenditure by the HOA to fund, upgrade and necessary services like power or water or sewage or anything like that. Do you have the authority as a manager to make that determination and go? Is there a defined process for that? How does that happen?
Okay, water and sewer and garbage are actually taken out of the HOA fees. That's how we pay for them every month. Right. The electricity is actually each individual condo owner has to go in front of Puget Sound Energy and contract for their electrical. That's why in 2011, August of 2011, we actually set up 5 different electrical panels, one for each unit. And each owner at that time had to pay for that electrical panel. And then they assumed all of the risk for the wires that go between the panel and their condo or their private property in the case of the shed. The rest of us don't have that. But anyway, so that's what occurred at that point. And so we do not consider the electrical as anything to do with the condo other than if something occurred between the street where the electricity comes in and then goes to the big circuit board, which I put a picture in there for you. Other than that, we would handle that, but we wouldn't handle anything other than that with electrical.
Okay. So from the point of the panel, you stop paying as the HOA and you expect each individual owner to be in charge of the condition of the wiring from the panel to their unit and all the appurtenances to their unit. Is that?
No, they're actually responsible for the electrical panel itself. I'm just saying that, there's a pipe that comes in the bottom of the 5 electrical panels where the whole electricity comes in, and then I'm not sure exactly how it works, but that's how it somehow or other, when somebody uses their electricity in their unit, it gets measured, and that billing goes to Puget Power, and each individual owner pays their own electric bill. So the condo has nothing to do with that.
Okay. Okay, so 2 things. One is your theory is that Ms. Jarvis said she had an inspection which said the wiring was not safe bringing the power to her unit, and that's, she began this electrical effort in order to upgrade the wiring for safety purposes. And it's your belief that that is the obligation of the unit owner, not the obligation of the HOA.
Exactly. And I actually, when you look at the bids that came in that Ms. Jarvis collected and her home inspection, there is nothing that talks about fire hazards. That's where she did get Jerry's attention, but we don't think he ever saw the bids and the home inspection. When you look at those, and I went into big detail on that with my statement, evidence and all that, because I had to type that up because I had to get the other owners to agree with what I was saying. That's why it's prepared. Anyway, the thing is that there is nothing. It talks about grounding problems, and that's your safety, but she says it would be a danger to any of the owners, their guests, or there's another word that she uses. And that's not true. A grounding is if you go into her shed and you use the electrical in the shed, you could be shocked. The other one was a fuse box, and it says that a fuse box, when used in tandem with an electrical panel, is unreliable. And so therefore, that's what they said for her to change it to a circuit board, I assume, or electrical panel. But there's nothing in there that says it's a fire hazard.
All right, so back to my original question. What's your authority as manager? Can you make decisions about HOA?
Is it a volunteer position?
Without the board? You have to take everything to the board?
Like you volunteer to
unless it's been something like, for instance, I can I can get the handyman out and have him do the jobs that the condo has given permission to do. In order to do a new project, I have to get the permission of the owners, and it's particularly brought to it's in rule. If you go to our bylaws on 39, page 39, you will see that there it actually has it. I believe it's number 3. On there, yeah, it's number 3. It says no major improvements shall be made to the common areas without the consent of the majority of the management group. Now, this would definitely be a major because it was 40%, 46% of the amount of money that we had in the checking account. And I had to pay the insurance within 4 months.
We're gonna have to raise the HOA.
So that's major.
Interesting that Jerry didn't ask for a vote from anybody. He and I just worked together, and you're his right hand, feet on the ground. So I'm surprised that he followed a different process here. I mean, at no time did he indicate that he had to check with people or get a vote.
Okay, so it sounds like there wasn't a vote. There's no history of this issue being raised with the HOA board.
No, the owners were surprised that they did see all the work going on. They did, but they did not realize that the condo was paying for it.
And you said that it's Article 39, is that what you said?
It's a bylaws. It's on page 39 and it's number 3. I have an arrow in front of it. It says no major improvements shall be made to the common areas without the consent of the majority of the management group. It's the bylaws. And Jerry was very ill. In fact, the week after he supposedly met with Ms. Jarvis on the 11th, he had a major seizure. He was in St. Peter's Hospital for a week, almost a week, because of this. And his wife said he went downhill from there, which is attached as evidence under manager's health on page 57.
Right. Yeah, I read that.
Okay.
Unfortunately, I wasn't privy to that information. So although we really mourn the loss of this man, whenever I worked with him, he seemed fully functioning and clear thinking and fully in control of the HOA funds until later in the year when he suggested he needed to step down.
Well, I actually didn't know that he had a brain tumor. I knew he was ill, but I didn't know he had a brain tumor. And I'm very familiar with that because I nursed my father-in-law until he died in our home. And the deal is that they had told us at the hospital that we had to bring in a certified nursing assistant to be with him. And I didn't understand that because he was totally and completely rational to us, to the family. As it turned out, one day the CNA didn't get there on time. So I went rushing back home, and the CNA and I both walked in together, and he had started a fire on the stove, and he was just sitting there looking at it. He didn't know what to do. And this man had been his own business.
I can't ascribe that to somebody else. I understand.
Yeah,
what you're saying.
but you think that they know what they're doing when they had a brain tumor, but they don't. That's what I'm saying.
Well, all right. Well, I'll say I actually have a brain tumor, so I hope you hold me to that same standard because I think I know what I'm doing.
Okay.
But you don't, Judge. But you don't know.
So it doesn't. One person's experience isn't necessarily another person's experience in that regard.
Yeah.
Judge is like, I know what I'm doing.
So I've opened up your version or your copy of the Declaration of Covenants and Conditions for Harbor House, and refer me again to the place where I'm going to find your indication about decision making by the manager and the HOA board, because I'm not finding it here.
No, it's under bylaws. So keep going. You're got to go all the way to page 39.
The handwritten 39?
Yeah. Sorry. Yes. And
No,
I might
that's
write
okay.
this for
Appreciate people's efforts to try to
clarify it. There's
just-
three things that guide us. One is the declaration, which is also known as the CCRRs, and then there's the bylaws, and then there's the RCW. But I'm afraid that Ms. Jarvis has the wrong RCW. I can point that out in the CCRR that she has the wrong one, if that would be helpful. And why it's the wrong one. I can do that. It'll tell you right there.
Okay.
Want me to do that?
No, I just found your bylaws. So.
Okay.
The issue with submitting things electronically, which is great, I can't just go one to the next. I have to go through every single page in order to reach whatever is loaded up after that. So it takes a long time to go through these.
Yeah, I got it. I went to my paper copy.
Yeah.
Yeah, I understand.
Okay, so I do see no major improvements shall be made to the common areas without consent of the majority of the management group.
In my experience was that Jerry usually did that if it was like a big sum of money.
So
Jerry is to blame.
You've been at the condo for how long?
14 years.
Okay. And
practically owned the place.
Mr. Riley was the manager for some
18
significant
years.
portion of that time.
Yes, he was the manager until December 7th of 2025. So he was manager for 18 years.
Okay.
So before me.
Yeah. And did you know him to make financial decisions regarding improvements without going to the board? Did he occasionally do that? Did he never do that? Tell me.
He occasionally did that, but they weren't major.
Okay. So would he say $3,547 is major, or would he say that's not quite major?
I would think he would have said that was major because he did go around and talk to everybody about the tree trimming that was done that was $3,250. That was that
Okay.
same year.
And decision was made that that was an HOA obligation or a personal
Yes.
obligation?
Yes.
Which?
That was an HOA.
So Jerry spent all the HOA money,
And if I
then
may
he
add,
died.
when he went around and asked about the tree trimming, he just suggested that he was going to get some trees trimmed. There was no talk of cost.
That's true.
And it would benefit him with his view, and not me, but I was new, so I'm happy to do whatever the HOA manager wanted done, including some fixing of a sidewalk in front of Miss Adams' unit. So there were lots of things getting done to improve the property, and he was clearly in charge and making sure that the projects were funded. So I had no idea that there was a process step that might not have been done because I trusted that he was the HOA manager and in charge of our funds.
Okay.
Judge, I see this as we can blame it all on Jerry because he's not here. Rest his soul. He was in charge. He made the decision. Spent the money. He was in a managerial position. Let's just let's stick it to the HOA, and in return, the HOA can raise their fees to be like $7,000 a month, and then everyone has to pay, and then the HOA wins in the end. Everybody's happy then. I may have a I may have a personal feeling on this one. Yes, we got trees. We completed our Foliage Friday quest, thanks to Thurston, Washington. The judge is currently on Zillow looking for places to buy that don't have HOAs. Wants to get out of his now. My goodness. Red pen. All right. Speak up, Judge. Bless us with your wisdom. I think if Jerry spent $3,200 on trimming the trees without... Oh, wait. Carolyn's going to come in again. She's got something. Write it, save it, Carolyn, until we're ready. If Jerry made that decision on his own and the HOA was responsible, then if he authorized this electrical work, which I sort of wasn't listening to, so I'm not sure what it entails, I think HOA has to pony up. This is a good point. How did Jerry have sole access to the funds? There didn't need like a second signer on any invoice or anything.
All right, so right now I'm looking at RCW 6434240, alterations of units, and this was an amendment to that original statute. It was adopted in 1989, and it's effective through January of 2028. And it talks about, among other things, alterations in electrical systems in the condominium. And it says, the board of directors shall approve a unit owner's request within 30 days or within such other period provided by declaration, unless the proposed alteration does not comply with this chapter or the declaration impairs the structural integrity of mechanical or electrical systems in the condominium. And then it says the failure of the board of directors to act upon a request within such period shall be deemed approval. Ms. Adams, any comments on that statute?
Yes, sir. That it does not cover our condo. We were established prior to 1990, and the 64.34 RCWs are after. And I have that actually stated on page 37. Actually, it's on page 38 at the bottom of my stuff. It says condominiums, it says notes on that page 38. And it says condominiums created after July 1990 is chapter 64.34 RCW. When you go to our declaration and you go to page, I think it's like 3 or 4, you find, no, it must be 3. In 1.8, under the definitions, no, it's actually under the, sorry, my fault. It's under the CC&R, the declaration, and it's under Article 1, and it's 1.18 section, and it says the condominium statute shall mean the horizontal property rhymes Act of the State of Washington laws of 1966 or 63, chapter 156, presently codified in chapters 64.32, the revised code of Washington. So since this was, we were filed.
Tell me which of your
Yes.
pages?
Okay, which pages is that? It's 7. Excuse me. I had it.
Your handwritten pages.
It's 9.
Okay, thank you. Okay. And that's part of the CC&Rs adopted by Harbor House?
Correct. Back in
Okay.
1982.
All right. Yeah, and so I think what you're telling me is that the state can't come in and change the obligations to comply with the statute that has subsequently been amended. Is that what you're saying?
Not sure what that
A
means.
1989 statute was adopted, different than the 1963 statute, and you're saying
Correct.
that because
Yes.
the CCRs doesn't recognize the 1989 statute, it should not apply?
Right. The 6434 does not apply. And that's actually stated in the pages that I have in front of you. It's on page 38 of my stuff. And it says notes at the very end of all the list of ones, the RCWs that pertain to us. Then it says notes. Condominiums created after July 1st, 1990 is chapter 64.34 RCW. But we're before that. So you're absolutely correct, sir.
Okay. That is I was curious what note it was, but it's a note actually put in there by the legislature.
Correct. Because they probably have problems where people pull the wrong one for condominiums. And that complies back with the declaration that we just went through, the Article 1 and the section 1.18.
Okay, thank you. And Ms. Jarvis, did you have anything else you wanted to add?
I guess I would just like to understand why the current RCWs don't apply. I think that's what I'm getting from this, is that
Well, the legislature indicated in its in its notes to the statute that was adopted in 1989 that it would only apply to condominiums starting in 1990. So they call that a grandfathering clause. They do that occasionally when they adopt legislation and say it doesn't apply to things previously existing, but it does apply to new things going forward. That appears to be what they have done here.
Oh, okay. So could you tell me how that applies to this then, specifically as far as the ownership and responsibility?
That the 6434 statute is not applicable. So it looks like you go to 6432 as the applicable statute.
Okay.
And then, among all the other things, you have the bylaws, you have the CCRs, and the various issues raised by both of you in this case.
It seems like our CCNRs echo the later RCW laws. And that's what I was looking at as far as the common areas defined as pipes, wires, conduits, antenna, and other fixtures and equipment for utilities. So I don't know, it feels like it's more of the same in the sense that the condo owners are not responsible for the external structure, infrastructure, outside of their immediate condominiums and paint in, floor up, that kind of thing.
Right.
I mean, I was just going on the judgment of our HOA manager who was involved with every step of this project and took the responsibility of paying for it.
Yeah.
So Miss Jarvis has like a good faith thing, right? The manager acted as if he was in the right. Miss Adams has the law on her side. I see the simple solution. HOA pays and raises the HOA rates. This is the pattern that is carried out in HOAs all over the country. How's this going to go? Judge, you got to make a decision. We can't sit here all day. here, Miss Adams. She's got more. She's got more. She's got like reason after reason. I think we're talking about $3,000 in electrical repair modification work. I think. You know, this is going to be the talk of the board meeting next month.
Take a short break.
I'm going to take a short break. Need some music. Your Honor, I need you to do this a little bit faster. It's really hard to skip ahead to when you decide to start talking.
Ms. Adams,
Here we go.
Ms. Adams, the HOA in last fall paid the electrical bill, and then upon Mr. Riley no longer being the manager, reviewed that and decided that the obligation was Ms. Jarvis's. Is that correct?
Correct, except for the tree light.
Right. Yep, I understand that.
Because it was her shed.
Right.
Yeah.
I don't own the shed. I have exclusive use of the shed.
Okay.
The shed is part of the carport. It's part of the main building. It's part of the overall.
No, it is not part of the main building.
Okay.
It's a
Yeah,
separate structure.
I don't need a debate here on that issue.
Okay.
I can see why murder would be an option for some people. I don't endorse that at all, but I can see why some people would get there. Okay, here's the deal. Miss Jarvis, if it's the community property, you have to share your wine with everybody. Okay? That's only fair. Carolyn, because the tree's outside, and she has a light on the tree, you have to pay the bill for the tree light.
When are we going to break for lunch, Judge?
think this ends with a restraining order. And the judge taking a lot of Excedrin. He's like, you're making my tumor hurt. They're right next to each other. They're in adjacent units. That would be funny.
I'm sorry, I apologize here. I lost Mr. Riley's note indicating his review of the budget that was in somebody's exhibits. I thought I had it, but
It's on September 19th. Hold on.
And where is it in somebody's exhibits? I know I saw it at least once.
Yeah, me too.
I think it's page 55, 56.
Of whose exhibits?
Of Jarvis, 55, 56.
Yeah, that's it. I know Ms. Jarvis said that it was that he was able to put that together, but he used the budget from the year before and he couldn't reconcile the bank statement.
Yeah.
Okay.
All right, I found it. I apparently skipped right by it.
It's easy to do, lots of pages.
Miss Adams said it's easy to do with lots of pages. What she was thinking, though, was it's probably the brain tumor. She could do this judge's job a little bit better than him, I think, in her mind.
And I think I have one last question. Ms. Adams, as a manager, I'll ask you, when there's an issue for HOA consideration, how does that work? What's the process for getting, I think that you said there are only 4 units, is that right? Or
right,
that's
correct. Yes.
So there are 4, there's a manager and then there are 3 board members. Is that how it works?
Yes.
And what does a manager do when there's a matter for HOA consideration?
Just ask for a vote. Usually we do it electronically because they're all very, very busy people. And we give 14 days time to respond.
Okay.
Okay.
All right. And that's been the process for how long?
Quite a long time for the special votes. We usually have an annual meeting, but we haven't even been able to. Oh my gosh, excuse me.
What?
We have.
The HOA's in violation? You haven't had an annual meeting?
Okay, sorry.
Does it
I didn't know which
dissolve?
vote it was. Okay, so I'm sorry, I've lost track of the question.
Quite. How long has this process been in effect for the?
Oh, okay. We used to have annual meetings that we met in person, but when COVID came up, then we stopped having them, and now we've just continued it with having it annual meetings with doing it by electronic as well.
Okay. All right.
Okay.
Thank you.
Doesn't really answer the question, but the judge says, never mind. I'm sorry I asked.
All right. That's as you can tell with the time we've spent on this case, that there are a lot of interesting issues here which are very close. This is a civil case, and the way I have to decide the case is just by what's called a preponderance of the evidence, which just means I'm going to decide who's slightly more favorable than the other by way of the arguments they're making. So in this case, there are a bunch of issues. One is the property, personal property or common property. It appears to me from a variety of things that have been said today and reviewing some of the documents that the property, generally speaking, is personal to Unit 3. So the benefit for the electrical change, even though it may have enhanced some safety for the common area, is basically to the benefit of Unit 3. However, the owner of Unit 3, Ms. Jarvis, apparently got the approval of the then manager, Mr. Riley, to do the work, and Mr. Riley sounds like eventually paid for it out of HOA funds, and everybody seems agreed that that's what happened. I inquired as to what was the authority of the manager, and the bylaws indicate that for major improvements, and it doesn't define major improvements, that the manager, in order to make a decision, has to have the acquiescence of the board. And in this case, clearly that didn't occur. It was Mr. Riley's determination that this expenditure was okay, and appears to, by implication, reading all the documents, appears to have authorized it basically by the fact that he paid for it. I do realize that the bills were sent directly to Ms. Jarvis, and Ms. Jarvis did provide an email she sent to Mr. Riley saying that she was going to have the bill sent to him, and I'm going to guess that he subsequently paid after those bills were sent to him. So theoretically, she was relying on him to have the authority to pay the bill on behalf of the HOA. So I don't think Ms. Jarvis's reliance was totally inappropriate. On the other hand, it appears to me that based on the bylaws that Mr. Riley did not have the authority to authorize the expenditure of $3,547.
So you're going to have to sue him.
Which is somewhere between, it's probably 35-36% of the HOA's annual budget, which in my mind would indicate that it's a major improvement. So when you're talking about something that's 1/3 of the budget of a funding agency, in this case the HOA, that to me is a major improvement as contemplated in the bylaws. That I'll find that Mr. Riley did not, in fact, have the authority to bind the HOA to the costs for the electrical upgrades to the shed and the storage unit. And even though Ms. Jarvis has a strong argument for her ability to be able to rely on what the manager says, in this case, I don't think the manager had the authority to make that statement. So I will deny the plaintiff's claim. Thank you all.
Thank you, Your Honor.
Ms. Adams, like, what does that mean?
Given that, we want to know where we put the electricity or the storage.
You're going to have to consult with counsel. I can't give you advice on that.
Okay. All right.
Okay. Thank you.
Who won?
Thank you.
Thank you. We can go now.
Yep, you're all set. Bye-bye.
Bye.
Who won? Who filed the claim? Did Miss Adams win? Carol will need an attorney to get the rights to the storage area. Claim denied. She won, but she didn't. I don't know who the plaintiff was. Nobody knows what the result was. Who pays for the tree light now? Is anybody getting any wine? Judge, you need to spell this out for those of us that that legal speak is not our first native language. Nobody wins. You all go home. Judge says, I don't want to do this anymore. I regret taking this job. I submit my resignation. And I'm moving. No more HOAs. Plaintiff was Carolyn. She was seeking Jarvis to pay that bill in full. The plaintiff, it was denied, meaning Jarvis doesn't have to pay, but now they have to spend more money on attorneys to figure out where the electricity goes and how to fix all that. And it's now community electricity in a private shed? Is that what we have now? Aha. Miss Jarvis, what I would do if I were you was install a really nice wine cooler in that shed. because you're probably going to lose one day, because they have the power to cut off the power to that shed. They really could. And until then, make them pay. Make them pay. Just milk it. Get that wine chilled. So, all right, there we go. That takes us all well past lunch. It's 3:00. It is a Friday. We've had verdict music. We've had foliage on a Friday. Yes, there's many more lawsuits to follow, and so much more money. Nobody won. Nobody's happy. I don't think anybody even knows what the result was. HOA is going to be big mad. They're going to raise the rates. They're going to raise the rates. And oh my goodness, who makes an HOA with 4 people in it? Yeah. All right. You all have worked really hard. I'm so glad we were able to jump from court case to court case to court case. If you missed some of them, go back. They were all worth watching, except for maybe one, but it's short, so you're good. We had the paw print on the like button. We got to see who got the puppy dog. Let's see. We had just so much stuff. So it's been a day, as they say. Had an overdressed defendant. Everyone should have bingo at this point. Should be done. Thank you very much for the 317 likes today. Appreciate that. Next week starts the KPD jury selection. I'm not sure how much of that's going to be televised. Might take a week to see the jury, but we are in the pool for coverage on that one. So we're gonna follow it. I think most importantly, we're gonna find out if Tupac is really dead, because that, I guess, is an item of dispute as well. Because to be found guilty of his murder, I think you have to prove that they're not alive anymore. That's one of the. It's in the fine print. There's a little asterisk at the bottom, by the way. They have to be dead for this to apply. So, to all the mods, thank you very much. To those who are going through some rough times right now, we know there are several of you. Thanks for sharing with us those difficulties. You're in our thoughts and prayers. Let us know if there's anything else we can do. Y'all are amazing. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again on Monday morning, which I have a gig on Monday as well. So I'm pretty sure we're not going to live stream late on Monday. We're going to end, it's going to be an early day because I'm going to take a bunch of stuff down to the city hall to live stream what could be more interesting than an HOA board meeting, because we have, our town has issues as well. So, all right, you guys have a good weekend. Have a good weekend. Bye now. We go. All right, we'll see you guys later. Bye-bye.
Don't miss the forest for the trees.
There's nothing in the order that restrains you from talking to cats.
Thank you.